Not the mentioning date.
But for non-prosecution,
Mention on Monday. It's not an urgent matter. Call the list.
Item number 1.
Please, I have elaborately recorded submissions of both sides. Especially, I have dealt with the judgments relied upon by GRSC, wherein Tej Prakash is common, relied upon by both the parties. Then in paragraph 45, I have held that revision of delegation of powers as made with a letter dated 24th August 2024 issued by Under Secretary to the Government of India and clause 3.2 of Schedule 1 of such revised delegation of powers provides Board of Directors is empowered to appoint on the posts in the rank of General Manager and above. But in the present case, court is considering claim of appointment of petitioners as class 4 employees in death in harness ground. Clause 2 of Schedule 3 of such revised delegation of powers conferred power on the chairman and managing director to appoint and employ assistants, officers, servants, laborers, agents, brokers, contractors, and other workers for any of the purposes as delineated in the scheme of delegation of powers. Therefore, 2006 policy frame, as per minutes of the meeting held on 24th March 2006 and 11th May 2006, ought not to be questioned since same is not approved by the Board of Directors. It needs to be recorded here that in paragraph 4 of the supplementary affidavit affirmed on behalf of GRSC in the writ petition being WPA 19565 of 2009, statements were made to the extent that steps taken for appointment under death in harness category in terms of 2006 scheme were against approved vacancies, and same was approved by the Board of Directors in its 266th meeting held on 14th September 2006. In the minutes of 319th meeting of the Board of Directors held on 31st July 2014, it was recorded that panel of dependents under death in harness category was frozen on 31st March 2006 in consultation with the union. Finalized panel of dependents duly signed was handed over to the union. Advertisements were made prior to all 4 phases of recruitments. In respects of first phase of recruitment, advertisement made in June 2006. For recruitment in second phase, advertisement was made in November 2006. For recruitment under third phase, advertisement was made in March 2007. And for fourth phase recruitment, advertisement was made in December 2007. From the said frozen panel of 31st March 2006, 170 candidates were appointed, but appointments under fourth phase could not be made against 105 vacancies due to objection raised by CVC. From the steps taken by GRSC in order to give effect to the said frozen panel dated 31st March 2006 and the statements made in affidavit in earlier round of litigation, it appears that petitioners are similarly circumstanced like 170 candidates who were appointed under death in harness category. Though it has been agitated on behalf of GRSC that the report prepared on previous occasion is not challenged in the writ petition, but such objection pales into insignificance, as in the prayer of the writ petition, mandamus is sought for against order rejecting candidature of the petitioners for appointment under death in harness category. Then in paragraph 47, I have held that as it is found from the letter dated 31st May 2024 of General Secretary of GRSC Limited Workmen's Union, that out of 49 petitioners, 30 submitted documents in support of their financial conditions. Rest 19 are directed to submit their documents in support of their financial conditions within fortnight from date before the chairman and managing director being respondent number 2. On receipt of such documents, financial conditions of the petitioners shall be assessed by the concerned authority of GRSC within a period of 6 weeks in terms of 2006 scheme without insisting upon the petitioners to submit documents from Revenue Authority. If necessary, concerned authority of GRSC shall be at liberty to conduct door-to-door survey and report shall be prepared within a said period of 6 weeks disclosing present financial condition of the petitioners. After preparation of such report, same shall be supplied to the petitioners within 7 days thereafter. If petitioners fulfill financial condition in terms of 2006 scheme, they shall be given appointment under death in hand category within a period of 4 weeks from the date of publication of report.
And so what is that 30 is what they have, what the union has already given to us.
Yes, all 49 out of 49, 30 submitted, 19 has not submitted.
So 19 you have
19 for 19, I have fixed 15 days time to submit.
to submit and 6 weeks. And so far as 30 is concerned,
Is already there.
it's already.
Item number 2.
Lord, the name was wrongly recorded as Niladri Sharma instead of Nandini Sharma for this too.
Issue. Matter has come up for correction of order dated 5th August 2025. Stop. In the cause title of order dated 5th August 2025 against the state respondents, name of the learned advocate Niladri Sharma shall be read as Nandini Sharma. Shall be read as Nandini Sharma. Stop. Department is directed to incorporate necessary correction. Stop. This order forms part of the order dated 5th August 2025. Tomorrow kora. Niladri Nandini. Yes.
Item number 3 to 33.
All the matter are analogous matters. Petitioner is counseling in the upper primary election process. Petitioner have come under the zone of consideration in the main panel. There is no doubt petitioner come under the 14,052 candidates which have been mandated by the Honorable Division Bench on Rajiv Brahmo's judgment. Petitioner, when petitioner was called for the participation of the counseling, petitioner is working at the relevant point of time in the 9, 10 or 11, 12 level in the better position. That is why petitioner could not appear, and petitioner also had hope that something will done in the
Petitioners, all petitioners are petitioners, all the petitioners in all the matters participated in personality test. Participated in personality test.
for everything.
All, and they are impaneled.
Impaneled at terms of the division bench judgment 14,050.
Now they were they lost the opportunity to participate in the
Participate
counseling
in
in the
the-
first phase.
Yes, and this issue is no more desintegrate. Similar order passed by your lordship as well and coordinate with even my lord last Wednesday, last Friday. The honorable division bench clear. We are not staying any proceeding verbal observation. We are not staying any proceeding regarding board belows honorable single bench proceeding. They can proceed accordingly.
No.
My lord, it is verbal observation.
Division bench did not
That is
make any such
personal feature.
observation. The
Content.
division bench did not
Content.
entertain my learned friend.
Yes, my lord.
He tried to mention the matter. He described himself as an intervener, but the court did not listen to him.
There is verbal
But
observation.
admit the petitioners to
Yes.
participate.
As on date, my learned friend is trying to say it is no longer res integra, but all these matters, except for 2 or 3 of the matters, they have already got the interim order, and we have filed our affidavits, and the affidavit is ready. We want to file the affidavit.
You
The
file it.
statutory bar is there, number 1. Number 2, with regard to the division bench, my learned friend is referring to last Friday. May I place the order which was passed?
No, how division bench, who has initiated the proceeding before the
The one of the empaneled candidates who has not been called for counseling has filed a contempt petition before the division bench. Following that, several other candidates also from the waiting list have also filed their contempt petition. So we are facing the contempt. In the contempt, what order has been,
contempt, what was the parent order passed by the honorable division?
that was the 14,052 are to be given recommendations, are to be called for counseling. That was the original order. But
These are the impaneled 14,052 is the total number of impaneled candidates.
yes, including the waiting list.
Now petitioners are coming under 14,000
Yes, yes,
candidates.
yes,
14,052.
yes,
Now, if petitioners are coming under 14,052,
yes.
then where is the difficulty in permitting the petitioners to
Yes,
participate?
the
in council?
difficulty is this, that since the 14,052 vacancies included waitlisted candidates, now waitlisted candidates, all of them are not getting the matching vacancies. So they could not be called for counseling. That is why the contempts were filed. Now, just kindly see what order was passed by the division bench on the last day in the contempt proceeding. The division bench is not taking account of absentee candidates. Kindly, this is the order. Kindly see the second page.
Just a minute. Now, that's why you are submitting that if vacancies, due to, if vacancies are available, the vacancies are available, allow them.
Yes, but what-
once counseling is conducted, they will lose opportunity. But in similar other matters, I have passed order.
But now this order was passed on Friday. What is the division bench scrutinizing after?
That division bench does not
Is final.
make any hindrance so far this court is concerned to pass.
Well, I
No,
have specifically. I
My
have
lord is
specifically
directing, my lord is directing counseling.
This court has accepted your contention that if vacancies are are available, subject to availability of vacancies, they are to be permitted. Because there was a specific contention raised on behalf of the commission.
That
before the Honorable Division
contention
Bench
was not
that-
our
that-
contention. That
that number
contention
of-
fell from the court.
There are total number of 5,401 vacancies. And the resultant initially 26 September to 2024, and there are steps taken. So and so, therefore, steps were taken for holding counseling. There are 1241 candidates to be called for counseling. However, 5,401 vacancies are there.
Now, let me submit. Kindly allow me to submit. The court is scrutinizing the position of 14,052. That why we have not done the counseling of all 14,052 candidates as per the original order. Here the court, may I place just the two paragraphs from page 2. Mr. Basu further submits there are still 1241 candidates to be called for
Out of
counseling.
14,052.
Not out of 14,052 in that sense, excluding the petitioners. Petitioners were absent. They are out of the picture. Court, it fell from the court that if you have vacancies, give, since we had the surplus. But the division bench has not said that. Division bench is hearing the matter.
Mr. Basu, here the Dr. Patro, here the consideration is completely different. Here the consideration I have passed in Mukti Vishwas and other
My
matters.
lords are not.
Justice Roy has
They
also
did not
passed in
drag
other
back to
matters.
the
Please
division
wait.
bench.
Justice Roy has also passed in other matters that since they have lost job, first. Second, they were not, court has never, no single bench has ever directed that diluting the merit you permit them, because they were there within 14,052
My lord.
and they could not participate because they are working at the material point of time. They lost job due to misdeeds of the commission, as I have held earlier. So therefore, they should be permitted. Now,
But
this
now I am
order-
only
this
submitting two
order is
things.
interfered with by the Honorable Division Bench.
Even my
Have you preferred appeal against Mukti Vishwas?
No, not yet,
Then-
not yet,
Then
not yet, but we have applied for the certified copies. We will have to
that-
file
that-
if this
that
con.
will not make any impediment.
No,
over
but this,
court.
this order which I am placing, kindly appreciate. The division bench is still looking into the matter with regard to 14,052 candidates.
Well,
The
Division bench will
division
look
bench
into
has
that.
accepted
Division
our
bench will
contention.
pass an appropriate order, but these candidates are within 14,052.
But the division bench has excluded them while taking into consideration 1,241.
This was based on the submission made on behalf of the commission that 1241 are left.
Yes.
Yes.
And that is why the court has made so many observations. Kindly let me read the order.
No,
then.
I have passed order in similar other matters. You have not preferred appeal against this order. So therefore, I have to follow my own.
These
order.
matters, my lord has refused the interim orders. These matters which are before the court today, all- not the interim, the order to appear has already been refused at the motion stage. We are at a hearing stage today.
Very well, but at this stage, if petitioners are denied of their right to participate in the counseling, because that was considered in a change circumstance, in a different circumstances, because court was under the impression that the seventh counseling was the last counseling, and it was not submitted that any decision was taken to.
No, I had clearly submitted
Now today,
that
if-
no further
if-
counseling had been advertised.
you tell me.
But
that
I
what-
did not
what
say,
is the
I am still
difference?
saying there will be more
What is the
counseling.
difference between the other matters where I have permitted the candidates to participate and the candidates today before me? What are the difference?
The difference
Qualitative
is
difference.
now the division bench, which
So
is
I
looking
cannot-
into the
I
matter.
cannot, Dr. Patro, I cannot pass different orders on similar issues. Try to
My lord has
appreciate
already done so.
I try-
My lord has already
try
done
to
so.
appreciate my predicament.
My lord has already done so. Initially, my lord was passing directions for filing affidavits.
When there was no decision for holding any counseling.
No, we never said there will be no future. Even now,
You have
Even now
submitted
there is no
specifically
decision.
some of the matters you have
even now, as on date, there is no decision for further counseling.
No, court
It is
has
a
done
natural
in
thing that
other similar other matters, court has directed and you have considered before the court, yes, on 1st of August, it will not be possible to hold any interview, counseling, but a subsequent counseling would be held.
But
to
that has not
accommodate
been
the-
advertised. That
accommodate
has
the
not been
candidates.
advertised. Exactly the same situation at the time of seventh phase
This
counseling.
question would not have arisen had these candidates not lost their job. That has to be taken into
Kindly record my
And it
submission.
is not the case that this 14,052 candidates, petitioners are out of this 14,052 candidates.
Kindly record.
Because they are the shortlisted and in-panel candidates to participate in the council.
But they are
Now, they
absent
did not
candidates. There is a
participate.
statutory bar.
Why, Mr. Dr. Patro? They are working in the post. They are working in higher posts. Now, subsequently, they have lost the job. You know the consequences.
Yes, I
Now, why they will not
understand.
be permitted
I
to-
understand, but then these 1241 will suffer.
One they will suffer. Because if you will get the meritorious candidate, then 1241 they will be considered. Why?
Yes,
why-
because
why-
they have forfeited
why-
their right.
No, because
By being absent, they have
That will
forfeited.
if you will get more meritorious candidate who are within the zone of consideration to the extent of 14,052 candidates, why this one you will argue on for this 14,000?
They have voluntarily chosen to remain absent.
Why you will
There
argue
is a
for
statutory
1200?
bar for absentee candidates.
Why your heart is burning for 1241 if they are less meritorious?
Because
Dr.
their
Batra,
turn has come.
Why merit will be
Because
given-
their
why
turn
merit
has
will
come.
be given go
They
by-
have
at
forfeited their
whose
rights.
cost- At whose cost this situation has
The
arisen?
petitioners have forfeited. My lord, only one thing. Kindly record my submission with regard
yes.
to 1241 candidates. That I have placed the division bench judgment. Kindly record this. That the division bench is still.
Where is Mukti Biswas's order?
And your lordship, Shafiqul
My lord,
Islam.
may I file the opposition? Let the
Yes.
opposition be kept on record and kindly record the order passed by the division bench. That I am submitting that the division
I
bench
fail
is.
to understand why your heart is burning for this 1200 and odd candidate, 1200 odd candidates, 1241 candidates.
I
If
can-
they are less meritorious.
I can
in
tell
in
the
the
court,
state-
but the court will not listen. I can tell the court.
Yes, please tell it, Bosho. Please tell me.
That will be something just coming from the bar. It will not be an instruction.
Yes, yes.
And the live streaming is also on, so I should not make these submissions.
Yes, please tell me why your heart is burning for 1241 if they are less meritorious.
Firstly, because these
But they will
candidates,
still a march.
first,
Over others who
no,
are in terms of
the
meritorious
waitlisted
candidate.
candidate is always less meritorious. But if the impaneled candidate chooses to remain absent, he cannot just come walking in later that I want to participate.
Under what circumstances, Dr. Patto, they chose not to participate?
Yes, and the second point, if I may submit,
who-
I should
and-
not.
And who
They
was-
will all leave the jobs. They will all leave. They will all take the jobs and they will all leave the jobs. The moment they succeed in 11, 12, 9, 10, they will appear a second time. Ask them whether they have filled up the forms. I'm 200% sure they have filled up the forms. They will get 10 marks for being in service and all these vacancies will come back. And the schools will.
Cannot be a consideration
It cannot
for
be.
a-
That is why I did not want to submit.
There can it be
That too on live
consideration? Please try
streaming.
to appreciate the yes, you perhaps you are right, but
The schools will all be vacant again.
Can that be a consideration before this court today, Dr. Patto? Tell me.
My lord, only record the division
will-
bench's
it-
judgment. I will not oppose.
Has to strike a balance.
Very well. I will not oppose further, but just kindly record.
No, you have right to oppose. You are representing the commission. If anything which impinges.
I
upon
have
the
to
right
finish
of
the
commission, you
process.
Have right to oppose.
I have to finish the process in
Do not
terms of the
hesitate to
division
oppose
bench.
before this court. But the thing is this, you at the same time, you need to appreciate what is passing through the mind of the
Yes,
court. and
I
some
understand.
Similar other matters. Court has
Same
considered.
thing also is passing through my mind. But again, at the same time, I have to conclude the selection process in terms of the division bench's judgment. That is what is
Court is not-
putting me in
court
trouble.
is-
My chairman is facing contempt.
Court is not interfering, Dr. Patto, in the process of concluding the selection process in terms of the solemn order of the Honorable Division Bench. And court is also saying that if available vacancies are there, matching or commensurating the category of the petitioner, as it is considered by the Honorable Division Bench in the contempt proceedings. But if petitioner comes within the zone of consideration and petitioner is one of the candidate within the ambit of 14,052, why?
And vacancy is lying idle.
Under these special circumstances, how their right can be ignored at this stage?
Very well.
Considering the plight of the petitioner.
Very well. But simply just record my submission with
Yes, that
regard
I'll
to the
record.
division bench.
We are making submission on behalf
That
of the
this
opposition. This court
124
has to record it.
This 1241 does not include the petitioners. And in our opposition, we have taken the specific point that the absentee candidate does not get a second opportunity. There is a
Yes.
statutory bar. These are the 2 points
Then
which
where is Mukti Biswas's order?
My lord, I have given. Second,
Oh, my lord, kindly excuse me.
Yes, file your affidavit in opposition.
Yes.
I am disposing of the writ petition, nothing
Yes,
to be
yes.
in this matter.
Very well.
Opposition.
affidavit of service in respect of CAN.
Relying upon Mukti Vishwas, I have passed several other orders. Where is that one of these orders?
That I have given, my lord. Sofikul Islam, Jalpaiguri division, Jalpaiguri.
Yes.
That matter, second matter. That matter. No,
That's one. It's a Mukti Vishwas.
Sofikul,
This is the contempt.
Sofikul. That
That's
that line.
অর্ডারটাও রেফার করো। তুমি নিয়েছিল এটা, হ্যাঁ। Whether the commission has taken any decision when the subsequent counseling is to be
No, madam.
conducted. All are from 19 or 9, 10, 11.
Or 19, only one is.
এই ইয়ে এখানটা না রেফারেন্সটা স্পেসিফিক দিয়ে দিই। দেখো the selection process that is first SSC 2016 for classes 9, 10/11, 12 এভাবে করে দিচ্ছি যাতে বারবার চেঞ্জ না করতে has been satisfied with honorable Supreme Court with the judgment dated 3rd April 25 delivered in the Delhi. In all cases, all the petitioners are coming within this 14,052.
All the cases.
Yes, yes. So therefore, they must be within 14,052 candidates.
Yes, yes.
If any candidate is called in the counseling, first phase
Yes,
counseling,
yes, 14,000.
then must be 40,
14,000.
because that is the total number of impaneled candidates after personality.
After person. In terms of division bench sort.
আচ্ছা এসো এইখানটায় এই প্যারাগ্রাফ 5টা চেঞ্জ করো, প্যারাগ্রাফ 5টাকে চেঞ্জ করে it is also submitted on behalf of
And my lord, my learned friend is saying including waitlisted candidate. Figure that
it is including waitlisted.
Yes, sir.
Including waitlisted. Panel plus waitlist after personality test
After person.
for conducting counseling. It is also submitted on behalf of the petitioners. All the matters can be disposed of by a composite order
Yes, 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 yes. That is
instead of passing separate orders. And yes, all the names will be there.
Yes.
Lordship, with one indulgence, Lordship, in item number 25, Lordship, I appear in the last occasion also, but my name has not been recorded.
Forget about it. Fresh order is to be passed. কি বলছি? একটা না কম্পোজিট অর্ডার করে দেবে, and some of the matters are at the hearing stage
Yes.
and some of the matters are at
Matter I have filed interlocutory application, can application in hearing stage and which are not filed can motion.
like this matter, first one, the hearing matter, affidavit is filed,
Yes.
opposition on behalf of the
Lordship,
commission.
in some of the matter, affidavits are there. In some of the matter, there was no direction, and I don't
Motion
think
stage.
Motion stage and hearing.
matters.
Motion stage.
Very well. It is submitted on behalf of the petitioners. It is submitted on behalf of the petitioners that all the candidates are either impaneled or waitlisted candidates. Panel as well as waitlist.
Possibly I am interfering, no other, waitlisted, there is no waitlisted candidate.
All are
All are equivalent. There is.
That's why they are called in the first phase
Yes,
counseling.
yes, yes. There is.
Or panel are impaneled candidates. Waitlisted দরকার নেই. Are impaneled candidates. Stop. Panel was prepared after personality test and it is submitted on behalf of West Bengal Central School Service Commission, hereinafter referred to as Commission. Stop. Total 14,052. Total 14,052 candidates were selected based on preparation of panel and wait list. Petitioners come within these 14,052 candidates. এইটাকে 5 নম্বর প্যারাগ্রাফ করে দাও, আবার বসে ডেকে নেবো। ক্যানগুলো সাথে ডিসপ্লে 8th round counseling was held on 1st August. ওখানে বসতে হবে একসাথে। যাবো আমি ধীরে নামটা এই দুটো লেখা এই দুটো আমার কোনো লেগে গেলে
প্রথম তিনটে পেজ দিলেই তো
There is no ouster of candidate who are going to participate in the next round of counseling. Because previously Dr. Patro submitted that if petitioner is permitted, another candidate from the panel would be ousted. That is not the position. It is as it appears in reference to the order passed by the Honorable Division Bench in contempt proceedings. Because there are 14,052 odd candidates who are to participate, who were to participate in the council. Now, if these 14,052 candidates are there and petitioners are within this 14,052, in terms of the order of the Honorable Division Bench, all the candidates have to be provided opportunity. So therefore, this submission is not required to be recorded, as it was submitted on previous occasion. Issue. এই প্যারাগ্রাফটা চেঞ্জ হয়ে একটা প্যারাগ্রাফ ওই যে ডিভিশন বেঞ্চের আচ্ছা another limb of submission which is advanced on behalf of the commission is based on order passed by the Honorable Division Bench dated 8 August 2025 in contempt proceedings being CPAN 589 of 2025 Sushanto Kumar Ghosh versus Mr. Siddhartha Mojumdar and another. According to the commission, it was pointed out before the Honorable Division Bench that though there were 5401 vacancies available against 1241 number of candidates, but there is mismatch of vacancies considering category of candidates who would participate in the next round of council. So it is also submitted that there are altogether 14,052, 14,052 candidates who were enlisted in either in who are enlisted in panel and wait list. Now, whose names featured in panel and wait list prepared after personality test, and they are required to be given opportunity to participate in counseling. Stop. Once petitioners who were part of 14,052 candidates, in spite of giving opportunity, remained absent in the in earlier rounds of counseling. Their right of participation in counseling gets extinguished. Stop. Go. Paragraph 9. all the petitioners are untainted candidates.
Yes, yes.
They are working.
Yes.
Particular person.
In some of the cases, applications are filed.
Yes. Because
Can applications in connection with pending?
pending.
So this can as well as writ petition both are to be disposed of.
Both are to be disposed of.
তিন নম্বরেই আছে can.
Issue. Paragraph 14টা চেঞ্জ করো। Since petitioners are amongst 14,052 impaneled candidates in connection with first SLST 2016 upper. this court does not find any impediment in permitting them to participate in upcoming selection in upcoming counseling, and that would not be contrary to the order passed by the Honorable Division Bench in contempt proceeding being CPAN 589 of 2025. Moreover, by permitting the petitioners to participate in the counseling, merit will not be diluted. And such participation in the counseling shall be subject to availability of vacancies. Availability of matching vacancies. বসুন। এসো। এটা কি হয়েছে এর সঙ্গে? Affidavits filed on behalf of the parties in connection with the matters are taken on record. File your all affidavits are taken on record. Stop. With the aforesaid direct observations and directions, writ petition, all the writ petitions and connected applications stand disposed of. Urgent photo steps are due.
এগুলো সার্ভিস আছে
এটা একটু দেখে নিও প্রথমটা যেন এখানে এগুলো বোল্ড হবে, বুঝতে পেরেছো? যেমন এগুলো বোল্ড হবে, ভট্টাচার্য বোল্ড হবে, প্লাস ওই পার্টিকুলারটা দিয়ে দেবে। হ্যাঁ, ওই পাস্ট ইন অ্যাপিল অ্যারাইজিং আউট অফ এসএলপি নাম্বার সো অ্যান্ড সো। হ্যাঁ, আচ্ছা, আর প্রথম দিকে কয়েকটা জায়গায় হয়তো সিঙ্গেল ওয়ার করার আছে, সেটা পিটিশনার সব। আর সব জায়গায় অ্যাসিস্ট্যান্ট টিচার ইন ক্লাসেস 9, 10/11 and 12, বুঝতে পেরেছো? আর কত কত জায়গায়, যেমন দেখো এই প্যারাগ্রাফটা, পিটিশনার্স অপটেড টু বি অ্যাপয়েন্টেড ইন অ্যাসিস্ট্যান্ট টিচার ইন সেকেন্ডারি, হায়ার সেকেন্ডারি section of government aided institutions according to the petitioner's way, তখন তো একটা একটা করে better opportunity for him, হাতটার করবে না, for them, বুঝতে পেরেছো? To work as an assistant teacher in secondary assembly rather than working in upper level of classes, as that would have been beneficial in terms of career selection. ঠিক আছে? এইগুলো দিয়ে দাও, এবার দাও। এই ফার্স্ট ফাইলটা না থেকে দাও, আমি দিয়ে দিয়েছি না, নাম দিয়েছি, আমি দেখে নিই, সময় লাগবে। এটা আপলোড করে দিতে বলুন। Give all your appearances. There will be no further correction. ঠিকঠাক অ্যাপিয়ারেন্স গুলো নিয়ে নাও।
নিয়ে নিয়েছি, ওখানে নিয়ে নিয়েছি, অ্যাপিয়ারেন্স সব দিয়ে দিয়েছি।
আইটেম নাম্বার 34। ওয়েট, আমি এটা শুরু করতে দাও। প্রথম ফাইলটা আগে রেডি করে তো আমাদের ওয়েবসাইটে নিয়ে
একটা ইয়ে আছে অর্ডার,
ঠিক আছে, তুমি প্রত্যেকটা রেডি করে তারপর সব পাঠাবো। ওটা আমার হাতে,
এটা ইয়ে আছে কারেকশন।
সেকশনটা পরে করো। প্রথম ফাইলটা তো প্রথম ওটা দাও, বাকিগুলো রেডি করে কারেকশনটা দিয়ে দাও। দিয়েছেন তো আগে, ব্যাস।
সম্ভবত এও এয়ার আছে। কারেকশন পরে পাঠানো। সঙ্গে পাঠিয়ে দিচ্ছি।
শোনো, এটা পাঠিয়ে দিয়ে এক্ষুনি আপলোড করে দিতে বলুন। Yes, call the matters. Call the list.
Item number 34.
Yes. Have you served notice? Upon whom?
My lord, item number 34, my lord, kindly permit me to appear through video conference, my lord. Because of my lord unavoidable circumstance, my lord,
Standing on
kindly
sofa,
grant me.
sitting on a sofa,
My lord, now chair, on the
Le-
chair, my lord.
leaning on backrest,
No, my lord.
like this. Is it the way to address the High Court?
No, my lord, no.
I will
Sorry,
direct the government period to delete your name from the panel.
my lord, I am extremely
Last
sorry,
occasion
my
you
lord.
did not appear, and now this is the performance of the government advocate.
My lord, actually,
How
my
much
lord,
cost is to be imposed upon you? I'll refer your matter to the Per Council.
no, my lord, I am extremely sorry, my lord, because of my lord fever, my lord.
Leaning
viral
on sofa,
fever.
you will appear before this court.
No, my lord, I am on the chair, my.
Yeah, you are doing this now. You are right. Now you are in the right position. After pointing it out, yes, Mr. Chatterjee, what is this? Last occasion he did not appear. I directed the learned advocate to serve a notice upon the learned advocate representing the state. And now leaning on a sofa, he is appearing before this court. Don't misuse this opportunity of appearing on virtual mode in this fashion. Few days back, High Court of other state has passed caustic remark when an advocate was appearing on virtual mode from his card. Yes, what is the matter?
Lordship, prayer for appointment on compassionate ground was refused by us. Next up, P32 minus. Next up, P8, page 32. If you know.
The correction is order process. Look at you. Item 62.
When your father died?
The 8 September 2017. The P2. Yes, sir. Computation was made by in order to demonstrate.
You are the son.
Yes. Some of the criminal. More than the.
You are not major at the time when your father died.
15.
You have no right. You are a minor. Your mother could have applied. Why she did not apply? You have no right. It has been decided by the division bench of our court. I was party to the division bench and I authored this judgment. Azim Ghazi. You have no right. In Orindam Chowdhury also, Justice Dotto sitting in division bench decided, which was relied upon by me sitting in division bench in Azim Ghazi. And in the recent judgment of Ajit Kumar versus Canada Bank, Justice Dotto in Supreme Court has delivered a judgment. You have no right. And moreover, this order was passed on 17 March 2000, and you have filed it after 5 years. You have filed it in 2025, and order is dated 17th March. Writ petition was filed on 20th June after 5 years, which goes to show that you have no financial requirement, immediate financial assistance.
Paragraph 15 was page 7.
What you have stated?
At that time of COVID situation.
Yes, sure. Employment doesn't require consideration of COVID. During COVID, we had to go to court where circuit bench. When you are pursuing a remedy by way of getting an employment on compassionate ground, there is no hindrance, and COVID should not be a valid consideration. And that was for a period of 2 years, 1.5 years, intermittently for a period of 2 years. So why it was not filed prior to that? And what is the object of compassionate appointment? Immediate financial assistance.
Yes.
Notice filed. Notice served upon the learned advocate representing the state respondents is filed today and same is taken on record. Next paragraph. Petitioner has questioned order dated petitioner has questioned memo dated 17th March 2020 asked by the District Executive Schools AC Bankura, being respondent number 3. whereby prayer of the petitioner for appointment on compassionate ground was spurned. Stop. Father of the petitioner was an assistant teacher of a government-aided secondary school who died in Hannes on 8 September 2017. Stop. At the time of death of father of the petitioner, at the time of death of father, petitioner was or petitioner did not attain, or petitioner was minor. Petitioner was minor. Stop. It is trite law that if a candidate seeking appointment on compassionate ground is minor on the date of the employee, he ought not to be considered for employment unless a relevant scheme relating to appointment on compassionate grounds contains specific provision protecting right of a minor candidate till such candidate attains majority. Stop. Next paragraph. Moreover, order was passed by respondent number 5 or respondent number 3. Order was passed by respondent. Moreover, impugned order was passed by respondent number 3 on 17th March 2020, whereas writ petition was instituted 5 years thereafter on 20 June 2025. Stop. Pursuing remedy after a period of 5 years in order to get employment on compassionate ground was to show that there was no immediate financial assistance required due to untimely death of bread earner. Next paragraph. Hence, at this belated stage, no relief can be granted to the petitioner. Stop. Writ petition stands dismissed. Next.
My lord, may I just submit one thing, my lord? I am just suffering from fever, my lord. Kindly consider me.
Item number 35.
And for the function.
Last one is the matter for extension of recommendation.
Karud appearance দেবে না for the state.
Since it is within 90 days. There is made the 90 days last occasion, my lord, is asked management whether vacancy is available or not. Since we are like the
Vacancies occurred.
vacancies are available or not, since we made a prayer within 90 days before expiry of the recommendation, made a prayer. We are relying neither Sultana. Lordship is asked to my learned friend whether the particular vacancy is available or not.
Just a minute. Yes. What is your instruction?
As per our record, my lord, no non-joining has been received by the commission, my lord.
No?
No non-joining has been received by the commission. That means that the vacancy is still there, ma'am.
I am relying my lord's.
Now you have approached within time of 90 days.
That is why Milord asked my country whether the particular vacancy is available since neither's order is also there for the other vacancies are vacancy are.
You applied on 14/24 December 2024. Page 18. Classes 9, 10. Against this order, no appeal was preferred.
No.
Very good, sir.
Now, who is to issue appointment letter? The secretary of the managing committee or the headmistress or head of the institution?
This appointment letter so far issued,
You have added head of the institution as party.
member secretary previous appointment letter has been the document very member secretary again.
Now the head is
The I shall add.
secretary of the managing committee issues the appointment letter.
But at page 15 is there, where member secretary ad hoc committee issued the document verification notice. So
Where? Page.
15, 1 5.
So why you have not made him made that
That is my mistake.
made him as party?
That is my mistake.
Page 15.
1 5. The task member secretary document verification, Kalagram Junior High School, member secretary ad hoc committee.
Now in that event, member secretary has to be served notice because school is not represented today.
Not yet, but I have served the head of the institution.
He's not the or he's not the appropriate authority. Sometimes head of the institution is is also the secretary of the managing committee. But if that is not the situation, in that event there is a difficulty.
The commission issued extended the recommendation, but accordingly school authority decide the system. Praxis period, the commission is the commission extended and the school authority accordingly, madam.
Issue. Based on the criteria. After extending validity of recommendation by the chairman of the commission, concerned authority of Kalagram Junior High School, Pakur, shall take necessary steps for joining of the petitioner in the recommended post. So before permitting the petitioner to join the post, school authority shall verify the testimonials of the petitioner. Stop. এই জায়গাটা পুরোটা চেঞ্জ করে দিন, বুঝলে? তারপর এবারে সব ঠিক আছে, শুধু যেটা খেয়াল রাখতে হবে তোমাকে, অ্যাপ্লাই করেছে ফর এক্সটেনশন 24 ডিসেম্বর 2024. For extension of validity of reliance is also placed on the judge dated 11th July 2025, passed by a on root petition PWA 12048 of 2025 within bracket Nahida Sultana versus State of West Bengal. He has disposed of
Item number 36.
Nine and 10.
Okay, good for interesting. Vice. This one. The part.
Corrections. এটা আছে সেটা করুন। State respondents and West Bengal Central Food Service Commissioner represent. Identical issue was considered by the state. The writ petition being WPA 130485 within bracket Nahida Sultan versus the state of West Bengal. Ratio of Nahida Sultana Supra governs the issue involved in this. Order judgment 11 July 2025 passed in delivered in Nahida Sultana Supra shall be retained with the record of this writ petition. Duly countersigned by Assistant Register Court. Get the copy, fresh copy. Next. Concerned authority of West Bengal Central Food Service Commission is directed to extend validity of recommendation dated 22nd November 2024 for a period of 60 days from the date of publication of this order, and permit the petitioner to join the post of assistant teacher in Palivhara Saraswati Vidyamundi, not 24 partners. Stop. Necessary order is to be passed by the chairman of the commission by 7 days from date of communication of the officer. The authority of Palivhara Saraswati Vidyamundi shall permit the petitioner to join the post in terms of recommendation dated 22nd November 2024 based on order to be issued by the chairman of the commission in terms of aforesaid direction. So, at the time of joining of the petitioner, school authority shall verify the testimonials of the petitioner. So, writ process has disposed of Next.
Item number 37.
Which for the commission?
And for the commission. Lordship, we have received non-joining of this vacancy, my lord, but we have not utilized it. It is still vacant.
ওইটা কোথায়? এটা যত
Where petitioner was recommended exists. Where petitioner was recommended still exists. But the next step, recommendation on 16 November 2024 and application was made on 31st January 2025. Recommendation recommendation 16 November 16 November and application date for extension of recommendation 31st January. আর স্কুলের নামটা চেঞ্জ হয়েছে মালঞ্চ হাই স্কুল এইচএস ঝাড়গ্রাম এই নাহিদা সুলতানটা থাকবে কাউন্টার সাইড যা আছে ঠিক আছে হ্যাঁ নাম
Item number 38.
The transfer application on self-medical ground. Well, she is that Tanushree Kormakar. As per liberty that your lordship refers that order, she has come before lordship. That
which order?
Tanushree Kormakar that it prescribed pro forma. That Tanushree Kormakar, in terms of division bench's order, she has applied for transfer that is pending for consideration.
When you have applied, where is that application?
116, page 116. 28th of May 2025, I applied. On self-medical ground.
Self-medical ground.
Self-medical ground. And my formal application is page 115. It's written over there.
Tanushree Kormakar,
That Tanushree Kormakar.
whose matter was considered by the division bench.
Terms of division bench's order,
What is the ailment?
serious gynecological problem.
Whether the school authority has issued no
No,
objection?
no, school authority has not issued.
Who is appearing for the school authority?
I've served my lord.
Find it out.
All delivered, so they can copy it. It was received by 7th July by the school authority.
Serve another notice. In the meantime, I'll direct the DI to submit a report as to why school authority is not issuing no objection.
Self-medical ground.
Self-medical ground. Yes, in all my school is not appearing in many matters.
What DI will be submitted?
DI will direct the head of the institution to come before him and apprise him why he is not. And this is being done regularly.
Yes, yes.
In spite of service of notice, I am telling you that there is a chance that petitioner will not appear. School authority will not be represented. So what in all matters, court will direct the local police station to ensure representation on behalf of the school authority.
Only one.
You are the DI, you are there. So therefore, if school notice is to be served, in addition thereto, you will submit a report where why the school authority is not issuing no objection.
The division bench's order last line clearly says in that event the authority will take conscious decision as permissible in law. So
Yes.
there is a direction of division bench
Issue.
to consider.
Affidavit of service filed on behalf of the petitioner is taken on record. It is submitted on behalf of the petitioner that an application for transfer on self-medical ground was made by the petitioner in prescribed format on 28 May 2025. But authority of Rukanpur High School within bracket HS Murshidabad being respondent authorities being respondent number 6 and 7 are not issuing no objection for consideration of transfer order, no, for consideration of transfer application of the petitioner by appropriate authority. Stop. It appears grievance of the petitioner is against aforesaid school authority. Next paragraph. Learned advocate for the petitioner is directed to serve notice upon the learned advocate and serve notice upon respondent number 6 and 7, enclosing copy of this order by 10 days from date and file further affidavit of service on the next date. Next paragraph. District Inspector of Schools, AC Murshidabad, being respondent number 5, is directed to file a report as disclosing as to why authority of Rukanpur High School within bracket HS Murshidabad is not issuing no objection on the transfer application of the petitioner. Stop. Let such report be filed by fortnight from date. Stop. List the matter under the same heading on. September 2021.
She's not an assistant teacher, she's a clerk. Clerk, possibly assistant.
I have never said anything.
Very well, I just like it. Great.
Single clerk in a school. What school will do?
No, there are other two persons are there.
Clerk.
No, duty is there. I understand, but rule is
Headmistress will be in soup if clerk is transferred.
someone else will come.
How the administration will run? Who will prepare the salaries, bills and other things?
There are other
There is difficulty.
duties there. They are doing all these things nowadays.
Tell them you will find in a school, in a secondary school, there are 2 clerks.
But HS school,
In
there
a
are,
rare school, posts are there.
yes.
You won't find.
More than 1,500.
Yes. Then only second clerk is there.
HS section 2,
The only clerk.
state is not taking any clerk in the.
This is the difficulty in appointing through school service commission. Previously, in older days,
Yes, yes.
local persons were appointed as clerk. So question of transfer does not arise.
Not arise.
Now people from faraway district are
Yes.
coming to work as clerk. So he will try to get transferred as soon as possible.
I mean, she's a
There is
widow.
problem.
And at the end of the day, institution suffers.
She's a widow and single lady, my lord, is difficult for her.
But the government and the authority has prescribed transfer rules.
And they're also
What
not
can be done?
appointing, they're also
Yeah.
not.
That cannot be given a go by.
Also, headmaster is the also is problem.
They are also
Yes,
not
next
appointing in the second post also, keeping it vacant forever.
In older days, you will find that a local person is working in a school as clerk. Group D. The question of transfer does not arise.
Even in primary, there was no inter-district appointment initially.
Now you will find a person from Murshidabad is working in Jalpaiguri as clerk.
Yes, yes, yes.
So he or she will try to get transferred as early as possible.
In Malad, for primary, there was no inter-district appointment. Now it is happening. Now so many transfer matters are now. Great,
Yes,
Nicola.
yes, next matter.
Item number 39. I for the petitioner.
Yes, you are for the petition.
My lord.
Yes, place your place.
This simply the payment of my applicant has been stopped arbitrarily.
Payment for what?
Salary payment.
From which date?
From the April of 2025. She was teaching at the school, but in the system it has wrongly shown the other school where she was got appointment letter, but she
April
not joined.
2025, petitioner is not getting salary.
Yeah.
Now petitioner is working in the school from which date?
He is working in the school from 2018 and this school on 2021. In the capacity 2018 from this school 2021.
2021, his petitioner is working in this school after being transferred.
After being transferred from another school, she got
So
the appointment
why
2018.
she is not getting salary?
Her name was dropped from the system and wrongly it is shown to a particular school, that is a school of Chopra school, which she never joined. Not only that, she got the appointment, she never joined, but system so she is
The
a teacher.
school authority you have served.
Yeah.
Don't say yeah before
Yes,
the
sir.
court. You are before the High Court. So it's not an happy word. Apparently, you look aged person. So you do not belong to
Sorry.
Gen Z.
Sorry.
So therefore, why you are saying yeah?
Sorry, Milord.
We can understand young advocate joined other day, he may submit in this fashion, but it is not expected so far you are concerned. Yes, where is the document from which it can be substantiated that the petitioner's service is being considered in respect of other school?
In page 31, my lord. She got appointed in Islampur school in appendix.
Yes, page 31.
Page 31.
Serial number 4. Where is the name of the school?
Islam is page 31.
Serial number 4. Where is the name of the school?
Page 32. I'm talking about Lord page 31. Islam Odlabari School.
Page 31.
Page 31.
Yes. There is no name of school.
Page 32.
Udlawadi High School is, but if petitioner is working in Jalpaiguri, why you have before this court? It should be heard by the circuit bench at Jalpaiguri. You are working where now?
In Dinajpur.
Oh, West Dinajpur. Yes, yes, place. But name of the school is Odlabari High School.
Transfer niche.
Jalpaiguri. Now you are. This is a wrong name.
Odlabari School. Initially, she got appointed 2000 in Odlabari School. Later, in 2021, she was transferred to Islampur School.
Yes, but this is the document of 2018. You were transferred in 2021. What is the wrong in it?
No question of 21. She was continuing from 21 in the Islampur School. She was.
Yes, but the document which you are relying upon at page 31 is dated 11th October 2018. That is prior to your transfer.
Transfer school ta
Page 31.
Page 40. Page 40.
No, এটা transfer school না.
Page 41, where it is being transferred to no, he was Choprabari School, Islampur School.
Page 41.
Page 41.
No, you have submit page 41 is the document, is a transfer order. 14 January 2019, appointment of to the post of assistant teacher. Classes 9 and 10.
Oh. 11 and 12.
But you were appointed based on the first SLST 2016, classes 9 and 10.
9 and 10 was appointed for the Chopra School, where the applicant refused to join. She joined as a high school teacher of 11-12 in the Chopra School.
In 2018, based on which selection process you joined?
SLST examination 2016 got appointment in a Odlabari School.
So where is your right? That selection process has been set aside.
No, in another, please, Your Honor, please see it. The election process, the list was there. When the list was published, when where it is mentioned, she was in 24 to have to submit a list of 15,400 candidates before the office of district inspector of school upon category not to be specially tainted. She was already mentioned not to be specially tainted, and her rank was.
Where is the list?
In page 5, it is mentioned.
Where is the list? Yes, where is the list, Mr. Das? that you are untainted candidate and permitted to work till 31st December 2025?
My lord, may please 42.
Yes, 42. Nothing can be ascertained from page 42. It's a part of list. What is this? This is part of list. That's why you are not getting a salary from April. Because Supreme Court delivered judgment on 3rd of April, setting aside entire selection process. That's why no salary from April 2025.
But other candidate of the same.
Where is the case made out? This is nothing. This document is nothing. Nothing can be ascertained from this document. No conclusion can be drawn up that you are a tainted candidates, untainted candidates. You have to make out your case that I am untainted candidates. I am entitled to work till 31st of December 2025. Where is such case made out in the writ petition? Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Stop. Petitioner, stop. Next paragraph. Grievance of the petitioner is she is not getting monthly salary from April 2021 or from April 2025, being an assistant teacher of a government aided high school or government aided school. Stop. Next paragraph. On perusal of a document at page 41 of the writ petition, it appears that petitioner was initially appointed on being selected in first state level selection test 2016 for classes 9 and 10. Stop.
My lord, leave may be guaranteed to produce the complete list.
Stop. Enters 16. Stop. কি বললাম সেন্টেন্সটা? For classes 9 and 10.
Lord, petitioner was a teacher in classes 11, 12.
11, 12.
Not 9 and 10.
But this come to page 41.
Yes, but the petitioner's case is that she did not join that school. She joined the 11-12 school. That is page
In Chopra school,
31.
she got the appointment for Chopra school, but she didn't join.
Page 41 appointment.
Kindly see page 31 first. Just for the factual aspect, I'm pointing.
Yes, otherwise the order will be wrong. So she was selected in
11, 12.
11, 12.
She got both 9, 10 and 11, 12, but joined in 11, 12. Page 41 is the 9, 10 recommendation which she did not join. That is her case at least.
But whether any case is made out that petitioner is an untainted candidate.
No, that is not clear because the annexure, that is P4, needs to be
It's a
checked.
cryptic one.
Yes.
Nothing can be, no conclusion can be drawn from this annexure.
But page 47, the petitioner's representation, there it is clear exactly what has happened.
Page 31.
Page 47.
His claim is that he wants to join as a primary teacher.
It was in a helpless situation.
What is a primary teacher?
Page 41.
47. 47.
Point number 6. Point number 6.
এটা ফাইনাল টাকা ফিরে যেতে চাইছে না কন্টেন্ট মামলা বাঁচিয়ে রেখেছি তোমার আসার জন্য ও নেয়নি ও নেয়নি ফর্ম ফিল আপ
চলে যাও। You have prayed for working in Islampur Girls High School as a teacher of class 11 and 12.
My
Where
lord.
is your right?
My lord,
Where is your right?
my lord, there is no such declaration from any end that I have been declared as a tainted or something like that. There is no such declaration from any end. So, my lord,
If there is no declaration, then you are hit by the judgment of the Honorable Supreme Court dated 3rd April passed in Boishakhi Chatterjee.
but my
Bhattacharya
lord,
Chatterjee.
I have been asked to or been allowed to fill up the form for 9 and 10, not for 11, 12.
Maybe, but both the selection process have been declared void.
My lord.
That will
But-
not improve your case.
But I have been given a further chance to appear before the next the selection test.
You appear if you are eligible, you
In
can
9,
appear.
10, but not 11, 12. In 9, 10, but not 11, 12. I have been given a chance to fill up the form for the.
That is not your case. Come to
This has happened
come
later
to
on.
paragraph
This
B.
has happened later on after filing the writ petition.
Come to prayer B.
My lord,
What is the prayer?
it is alternative prayer.
So
that
that cannot be considered by this court. According to your sweet will, no case is made out here.
my lord, kindly sees that has been.
Unfortunate case. Petitioner was working as an assistant primary teacher. Leaving job, selected in both 9, 10, 11, 12.
Yes, my lord.
Took a job in
11, 12.
11, 12. Lost job.
And now I have
Primary school teachership gone.
Supreme Court allows the
Teachership
candidate to
assets
go back to
teachership done.
primary. The Supreme Court allows the candidate to go back to the original appointment. Candidate is to apply before the authority.
Yes, go back to your original post. But whether it is a government post, Supreme Court has said in case of government post,
Primary teacher.
not primary teacher, post of primary teacher.
That I will have to.
Yes. Paragraph 47, some of the appointed candidates who do not fall within the category of tainted candidates may have previously worked in different departments of state government. state government or with autonomous bodies itself. In such cases, although their appointments are cancelled, these candidates will have the right to apply to their previous departments or autonomous bodies to continue in service with those entities. The applications must be processed by the respective government departments or bodies within 3 months, and the candidates will be allowed to resume their positions. Further, the period between the termination of their previous appointment and their rejoining will not be considered a break of service. The seniority and other entitlements will be preserved and they will be eligible for increments. However, for the period they were employed under disputed appointment, no wages will be paid by the state government or autonomous bodies. Further, if required and necessary, supernumerary posts may be created for persons appointed in the interregnum. Departments of state government, autonomous body.
Now, after filing of the writ petition, what happened, my lord? I have been allowed to fill up the form for 9-10. And they are showing me as a teacher of Chopra High School of 9-10. Although I did not join there, despite getting the appointment letter.
service count করে তাই
Petition affidavit of service filed on behalf of the petitioner is taken on record. Stop. Petitioner previously worked as a primary teacher under Uttar Dinajpur District Primary School Council for the period from 2nd March 2010 to 26 September 2018. Stop. Petitioner participated in first SLST 2016 for classes 9-10 as well as first SLST 2016 for classes 11 and 12. Stop. In both the selection process, petitioner was selected. However, petitioner opted to be appointed as assistant teacher for classes 11 and 12. Stop. Petitioner joined the post of assistant teacher on 27 September 2018. Stop. In 2020, petitioner was transferred to Islampur Girls High School, Uttar Dinajpur. Stop. Petitioner complains of non-payment of salary from April 2025. Stop. Prayer is also made which would permit the petitioner, or prayer is also made to permit the petitioner to function as assistant teacher for classes 11 and 12 in Islampur Girls High School. Uttar Dinajpur. Next paragraph. It is rightly pointed out by the learned advocate representing West Bengal Central School Service Commission, as well learned advocates representing West Bengal Central School Service Commission, as well as state respondents, that entire selection process, that is first SLST 2016 for classes 9, 10 and 11 and 12. Classes 9, 10 and 11, 12 was set aside by the Honorable Supreme Court, vide judgment dated 3rd April 2025, passed in civil appeal arising out of special leave petition within bracket civil, close bracket number 9586 of 2024, within bracket State of West Bengal versus Boishaki Bhattacharya within bracket Chatterjee and others. Stop. Next paragraph. Therefore, it is discernible. Next paragraph. Therefore, it is discernible as to why petitioner is not getting salary from the month of April 2025. Stop. Petitioner lost job in terms of judgment of the Honorable Supreme Court dated 3rd April 2025. As the selection process, that is first SLST 2016 plus SLST 26, first SLST 2016 for classes 11 and 12 was declared void. Stop. No, and stop. Stop. Next paragraph. From the case made out in this writ petition, inference cannot be drawn that petitioner is untainted candidate. Hence, no relief can be granted to the petitioner. Stop. Writ petition stands dismissed. Urgent Xerox certificate copy. See the situation. 9 years primary teacher.
Item number 40.
This is this below the candidature of the petitioners to participate in the managing committee has not been possible. So I am coming to the case below. Right, that in the year 2013, it was converted into sponsored. And the rule became law in 1972 management.
Who are you?
I am the Milord founder. My father was paid the land for setting up the school in the year 1965. On the basis,
But in terms of 1972 rules,
yes,
governing government-sponsored institutions,
yes,
whether any recognition of founder member is there?
No. But 5II law, in terms of the 5II, this is the rules. In terms of the rules 5II, there is a specifically below stated below 2 representative of the body.
5I.
5II.
Just a minute.
Composition of the committee.
2 representatives of body organization society. But in contradistinction to this provision, if you fall back on the earlier provisions, as contained in 1969 rules, there is a specific founder
and
member.
donor category. Yes.
But in paragraph 5 II, it says that two representatives of the body, organization, society,
Yes.
not the founder member.
Lordship, then in the year 20.
Suppose Ramakrishna Mission Society
Yes.
founded a school. So representatives of that society shall be representation of that society to the extent of 2 persons shall be on the managing committee.
Yes.
But here you are the founder member. In founder member, is there any separate recognition granted by this rules?
Rules 5II, my lord, body/organization/society. Then, my
So
lord,
where is the society?
then, my lord, your lordship kindly see.
Show me that there is presence of any body, organization, or society.
Then, my lord,
It was an individual effort to start a school.
in setting.
That's why you are founder member.
Setting up and cooperate for institution, my lord. In this regard, my lord, I want to say before your lordship, my lord, in the year 2014, there was a election in the managing committee. Now I could not annex this document, my lord. Your lordship.
Previously, you were member of the managing
Yes.
committee as founder under the category of founder.
Under the previously, my father was the member. Thereafter, I was the member in the managing committee. After 2013, there was a.
Is there any hereditary right? That
There
if
was a-
father is founder, then the
Yes,
son
yes.
can be considered as founder.
There was
Show me
a-
any provision in 1969 rules.
69 years.
Yes, show me any provision.
In the deed, my lord.
Suppose X is founder member.
Yes.
Then Y, being the son of X, also to be considered as founder member, where it is provided?
That is in the deed. It was in the deed, my lord.
Maybe in the deed, in the rules, 1969 management rules, where is the provision?
The 1960, my lord. That, my lord, I'll submit. I'll submit. In the
Rule
year
6A. Come to rule 6A.
Yes, sir. 6A.
Here is the problem.
Management of recognized non-government aided institution rules 1969.
1969.
Just a minute.
Now,
Just a
now-
minute. Just a minute.
yes, now in the 72, my lord.
Had you been founder member, question would have been different.
At present,
For generations to come, all will be founder member. Where is the provision? Just a minute. Just a minute. Just a minute.
At present, my lord, I am not founder member, but I cooperate the school for setting up the institution. On that ground, my candidature was, my lord, allowed by the district inspector of schools. And thereafter by the school was, my lord, allow me.
Come to rule 6A of 1969 rules. Rule 6. Composition of the committee of an institution other than that sponsored by the state government. 1. 6
founder-
1. Yes, read it.
One founder to be chosen in the manner provided in Rule 6A.
Where is the provision that a son of a founder is to be considered as founder?
So that was not at that point in time. I consider, my lord. Now, my lord, in the year 2014, my lord, the managing committee again constituted. Your lordship kindly sees the.
Where is the provision that a son of the founder member to be considered as founder?
My lord, at that point in time.
I have donated land. I am to be considered as founder. My son, my grandson, my great grandson will be considered as founder. Where is the provision?
But at that point of time, that was considered by the school authority as well as the board by order passed by.
That does not confer right upon you
That-
unless and until there is a statutory provisions recognizing you being the son of the founder member. You have no right.
Now, in terms of this honorable High Court's order, I was placed in the managing committee.
Show me any provision after transformation of the school from government aided recognized school to the sponsored institution. Son of the founder is to be considered as the founder member of the school managing committee.
That, my lord,
Yes, sure.
my lord, now, my lord, This is not my case. My case, my lord, in terms of the rules 1972.
Petitioner, affidavit of service filed on behalf of the petitioner is taken on record. Stop. Next paragraph. Petitioner is
Kindly
admittedly
consider these documents.
Petitioner is admittedly son of a founder member on the managing committee of Lodna Mankamar Vivekananda Vidya Mandir, Bankura. Stop the vein. At the material point of time when the school was governed by management of recognized non-government institutions within bracket aided and unaided close bracket rules 1969. Subsequently, ওই ওপরে না এই লোডনা সোয়ানস স্কুল হিয়ারিং আফটার রেফার টু সেট স্কুল করে দিল subsequently said school was converted into a government recognized institutions or no converted into government sponsored institutions stop admittedly a government sponsored institution is governed by management of sponsored institutions within bracket secondary close bracket rules 1972. Stop. Next paragraph. Petitioner prays for his inclusion in the managing committee of the said school under the category of founder member. Stop. Next paragraph. Question arises for consideration whether son of founder member is required to be considered as founder member of the said school. Likewise, his father, in absence of relevant statutory provision. Stop. In terms of management of recognized non-government institutions within bracket aided and unaided close bracket rules 1969, there is no provision that son of a founder member on the managing committee of the school is required to be treated as founder member. So, rule 5 within bracket 2, now. Rule 5 within bracket Roman small Roman 2 II. Rule 5 within bracket II of the management of sponsored institutions within bracket secondary close bracket rules, 1972 contemplates two representatives of the body slash organization slash society aiding or cooperating with the state government in setting up the institution can be part of managing committee of sponsored institution. Admitted, indisputably, in the present case, no existence of body slash organization or society is found which aided or cooperated with the state government in setting up the institution. Therefore, petitioner cannot claim benefit of Rule 5 within bracket II of 1972 rules. Moreover, 1969 rules does not recognize son of original founder member can claim membership of the managing committee. Next paragraph. Since no relief can be granted to the petitioner, writ petition stands dismissed. I am keeping your rules. You will get it back after order is signed.
Not kindly, Lord. Kindly, Lord, peruse the DI's letter, below. Written to the deputy
is not required.
Kindly see
I am to DI. What DI is saying is not required. What is required is what rule says.
Yes, rule say 5 II, my lord.
DI may have said anything
Yes.
without considering the relevant rules.
Yes,
Nowadays, many district inspector schools do not know these rules. What was there in Rule 6 of 1969 rules?
DI rejected, my lord. DI rejected earlier against that writ petition file.
Yes, please. Next matter.
Kindly see that.
Sorry.
Sorry,
Next matter.
Item number 41.
Yes, my lord. Lord, this is the case, the school run by special rule for the Adya Prathinidhi Sabha.
Yes.
For the special rules run by the Adya Prathinidhi Sabha. The petitioner applied for initial.
What you are praying for?
Praying for there is no scope for transfer because this is the run by the special rules. The similar circumstances the government has considered in respect of Ramakrishna Mission's teachers. My humble submission.
But in previous occasions, I have released Arjo schools under Arjo Prathinidhi Sabha. Take it back.
I am for the school authority.
Previous occasions, I have released. Matter stands released on personal ground and be placed before the Honorable Chief Justice for assignment.
Get Item number 42.
Yes, 42.
Of your lordship to place my case, my lord. Your lordship has been dealing with the upper primary matters, my lord, where your lordship has allowed
Louder, please use microphone.
Your lordship has, my lord, taking up the upper primary matters where your lordship has passed orders allowing candidates to participate in the counseling process, my lord. This candidate, my lord, is a para teacher, my lord. In the same process, my lord, he has uploaded the documents, my
The
lord.
para teacher's position is not akin to a candidate which comes under the purview of 90% of the vacancy.
My lord.
Para teachers counseling has not started. It was pending before this court in connection with other matters.
Not conducted. I had been called for the offline document verification, my lord.
When?
On 16th February 2024, my lord. Subsequently, that document verification process was cancelled due to the ensuing elections at that point of time, my lord. Pursuant to that, my lord, the personality document verification, my document verification.
Because
is-
it has not been started.
My lord.
Issues are pending before this court and the matters are being heard. So far, para teachers are concerned who have applied in respect of 10% of the vacancy in connection with first SLST 2016 upper primary.
I have applied under and I have received the call under the para teacher category.
So at this stage, yes,
Let
what
this matter be adjourned, my lord. In the meantime, others matter be heard.
so what you have prayed for?
Lord, I have prayed for
Verification of your testimonials.
or verification of testimonials, my lord, offline. I had
But
applied.
that has not started now.
No,
Whether the
ma'am.
verification is complete in connection with 10% very well, come at 2. Yes.
Item number 42.
My lord, relating to para
Louder,
teacher.
please, louder, please. I cannot hear
Matter
you.
relating to para teacher, my lord.
Yes.
And I praying for, my lord, allowing me to participate in the offline document verification process, my lord. I have already participated in the online process, my lord, but the offline process has not yet been conducted, my lord. I have made a representation to that effect, my lord. It is at page 55, my lord.
What representation? There is no scope for consideration of the representation. Because matters are pending on relating to continuation and conclusion of selection process, that is first SLST 2016 upper primary for para teachers, for which 10% posts are reserved. So therefore, at this stage, commission is not in a position to consider your representation.
My lord, in similar matters, my
You
lord,
participated in the verification process, and after that, no steps have been taken.
Right.
That is the
my lord,
position.
in the offline daily verification process, I could not participate because it
Let
was
it appear
cancelled
in
at
the
that point.
monthly combined list of September 2025. In the meantime, any order is passed, which touching upon the issue involved in this writ petition, you bring it to the notice of this court by mentioning the matter, court will accommodate. Yes.
In similar matters, your lordship has already passed orders for a
But now
report,
all
my
the
lord.
matters are being considered en masse, analogously. So therefore, at this stage, there is no further order is being passed by this court. And it is not the fact that the process will be concluded shortly. Unless and until those issues are decided, nothing can be done. Petitioner participated up to the stage of verification of testimonials relating to first state level selection test 2016 upper primary for 10% posts reserved for para teachers. So it is submitted that after verification of testimonials, no steps are taken for logical conclusion of aforesaid selection process. Next paragraph. Learned advocate representing West Bengal Central School Service Commission submits that issue relating to first SLST 2016 upper primary in connection with 10% post reserved for para teachers are pending before this court, and writ petitions are being heard. Or are pending before this court. Stop. Writ petitions are being heard. Pending before this court. Stop. Next paragraph. In view of aforesaid submission, matter in view of aforesaid submission, present writ petition ought not to be decided finally. Stop. List the matter under the same heading. Motion. List the matter under the heading motion in the monthly combined list of September 2025. Next. Those matters are fixed on Thursday.
Yes.
Item number 3.
My lord, I for the petitioner. The affidavit of service. Here. The matter relative to the family pension, but in respect of CPF to PPA. Husband of the petitioner retired prior to pronouncement of judgment of Obijit Vaidya. Subsequently, died. The widow has come before your lordships to exercise the pension on behalf of the petitioner, subject to payment of.
But at this stage, 13 June 2016, notification has lost its force because it was for a period of 3 months.
There is even two division bench judgment, one my lord Mukti Pal and another my lord the Sefali Das. Those are my lord permitted, my lord, subject to payment of my lord the interest and additional interest, and together with my lord the additional interest up to date. And based on that, my lord, all my lord the single bench has been passed several judgments. If my lordship will
Yes.
my lord. Firstly, my lord, may I permit to Sefali Jana? This is a division bench. It was my lord state was separate. Then, my lord, kindly see the Gauri Bose single bench judgment.
That is not the purport of paragraph 76 of Abhijit Boitto. It was specifically confined to the pensioners.
That has been
If I do not get pension, where is the question of granting family pension?
subject to correction, your lordship. Paragraph 4 and
Let
paragraph
it be decided on affidavit. Entire right emanates from this judgment of Abhijit Boitto. Now, Abhijit Boitto is silent with regard to widows. Abhijit Boitto is silent after expiry of 3 months period. So, for eternity, this will continue.
subsequently another division main judgment, my lord, Mukti Mohipal, the present, my lord, the incumbent also, my lord, now, my lord, they are permitted to, my lord, switch over and, my lord, taking subject to payment of, my lord, an additional interest. And
Petitioner's husband did not opt for pension.
no,
When petitioner's husband died?
2020.
20.
Yes,
20.
When this circular was issued? 13 June 2014.
14.
So therefore, when the husband did not opt for family pension, what is the question of granting family pension to the wife? Because right emanates from the service of the husband. If the husband did not opt for pension, where is the question?
Here, my lord, division base says that paragraph number 17.
এই একটা সিপিএফ জিপিএফ কনভার্সনের একটা ইউজুয়াল অর্ডার দাও।
I have another division bench judgment.
That will be considered a time of final hearing. If you straightway can substantiate before this court that it is permissible under Abhijit Boitto's judgment, I can accept. Because if this court is confronted with two judgments, one delivered by division and another by the larger bench will prevail upon me.
Subject to correction of the larger
Yes.
bench, my lord, it has been, my lord,
Abhijit
discussed.
Boitto is a larger bench judgment. So if Abhijit Boitto is silent with regard to the right of a widow, and if this court is confronted with the two sets of judgments, one by the special bench and another by the division bench, court will follow special bench.
Considering the larger bench, my lord, the Jharna Bhattacharya has been clarified in the respect of, my lordship knows, my lord, very well, my lord, better than me, my lord.
When husband retired?
My lord, husband retired, my lord, 2002, my lord, 30th November, September 2002. Up 30th September 2002.
Died?
My lord, died on, my lord, 18 October 2020.
Is affidavit of service filed on behalf of the petitioner is taken on record. Stop. Petitioner is widow of a deceased teacher who retired on 30th September 2002 and died on 18th October 2020. Stop. Admittedly, husband of the petitioner obtained retirement benefits under CPF scheme, and in terms of government notification dated 13 June 2014 issued by the concerned state authority, as per judgment of the special bench dated 16 July 2013, judgment of the special bench dated 16 July 2013, passed on intra-court appeal being APO number 94 of 2009, within bracket state of West Bengal and others versus Abhijit Boito and others. Husband of the petitioner did not exercise option to switch over from CPF to GPF cum pension within the time stipulated in said government notification dated 13 June 2014. Stop. Ultimately, husband retired on 30th September. Ultimately, after death of husband of the petitioner on 18th October 2020, the widow being the petitioner hearing, is praying for conversion or is praying for switching over from CPF to GPF cum family pension. Next paragraph. Prima facie, it appears, right of widow emanates from the service of husband who did not opt for switching over from CPF to GPF cum pension in terms of government notification dated 30th June 2014 within the time stipulated therein. Stop. During course of hearing, reliance is placed on the order dated 24th August 2023 passed by Honorable Division Bench on an intra-court appeal being FMA 620 of 2018 within bracket State of West Bengal and others versus Shefali Jana and others. Stop. Next, however, issue needs to be considered on the anvil. However, issue also needs to be considered on the anvil of the judgment of the special bench dated 16 July 2013 passed in Abhijit Boito Supra. Next paragraph. Let affidavit in opposition to this writ petition be filed by 4 weeks from date. Stop. Affidavit in reply thereto, if any, be filed by 2 weeks thereafter. Stop. Next one. Petitioner shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging affidavits. All parties are present. Apart from state, other parties are not there.
Item number 44.
Previous matter. Para-teacher. এই প্যারা টিচারের যে অর্ডারটা করলে প্রথমে
My lord, only difference here is that, my lord, in the previous matter, my lord, the petitioner uploaded the online documents and was due to be appear for the offline verification, my lord. Here the petitioner prayed for a direction, my lord, to participate for online document. The prior stage of.
But if that stage is for verification of testimonials, can it be extended, Dr. Patro?
Actually, it should not. Should I let it simply go to the monthly list like the other matter? Then when it is heard, we will.
সেম অর্ডার করে দেবে পিটিশনার্স যেটা ও দাঁড়িয়ে ছিল না আগের ম্যাটারটা
42 my lord, item 42.
মান্থলি লিস্ট অফ সেপ্টেম্বর ফাইল অর এফিডেভিট সার্ভিস.
Only one more thing, my lord. In item 42, my lord, I could not forgot to file the affidavit of service. May I be permitted to file my service, my lord? In item 42.
প্রিভিয়াস ম্যাটার ইয়েস ফাইল ওই 42 তে ওর এফিডেভিট সার্ভিসটা নিয়ে নাও আর ওটা রেকর্ড করে দাও. এফিডেভিট সার্ভিস ফাইলড অন বিহাফ অফ দ্য পিটিশনার স্টেটন অন পিটিশনার বা পিটিশনার্স কি আছে
Item number 45.
Same.
Deficit copy, the order you not put it.
up to the stage of document verification.
What happened, my lord? At the time of my lord, the interview, but subsequently that time they have no, because one of the similar situated
I think many matters I have heard you,
My lord,
so
this is
there is no
also-
question of any improvement further. Nine, 10, 11, and 12. এখানে তো এগুলো বের করে না সুপ্রিম কোর্টে কারেকশন You have not preferred any representation.
Yes, page 243 one. Second volume.
All the candidates separately preferred representation.
But
এই যে কোথায়
43 in second volume.
ঠিক আছে whether the board is party. West Bengal Board of Education party. You are appealing. Who is for the state? আরাম করছে বসে বসে
8 তারিখের মধ্যে করার কথা। 140 নম্বর।
না না আছে, ঠিক আছে।
এটা assistant, এটা assistant। কোনো সূত্র মাথা assistant।
এই শোনো, up to 6 অব্দি, প্যারাগ্রাফ 6 অব্দি সেম রেখে দেবে, সেম ইস্যু সেটাও। হ্যাঁ, প্যারাগ্রাফ 8টাকে সেট আউট করবে। তারপর একটা প্যারাগ্রাফ অ্যাড করে, it appears that issue has already been decided by this court on a writ petition decided by this court with a judgment dated 7th August 2025, delivered on a writ petition being WPA 14049 of 2025 within bracket Taposh Pramanik and others versus the state of West Bengal and others. কি বললাম? It appears that ratio of Taposh Pramanik Shukra also Pramanik Shukra governs the present issue involved in this. copy of the judgment dated 7th August 2025, passed in Tapos Pramanik Supra, is retained with the record. Tapos Pramanik Supra, countersigned by Assistant Register Court, countersigned by Assistant Register Court, is retained with the record. Stop. Next paragraph. Placing reliance on Tapos Pramanik Supra, present writ petition stands disposed of. Dismissed. Urgent xerox. Present writ petition stands dismissed. Urgent xerox. No use of passing orders one after another. Yes, I have recorded.
Item number 46.
Nineteenth August 2020. Thereafter, on representations around 10th September 2020.
Your father was working as?
Assistant. Yes,
19th August 2020 died.
Yes.
Then what happened?
Thereafter,
You applied on, where is your application? Page 15.
Page 2.
Page 15, annexure. Who made application? Wife or the son?
Son.
Son.
Joint application, daughter and wife.
Daughter and?
Wife. Wife of the deceased.
Just a minute. Just a minute.
Daughter made an application.
Just a minute.
On page 16, P2, my presentation.
Yes, P2. Then?
Yes. And thereafter, the sponsor of the school, he sent all documents. Before the DI. Now, ultimately, DI rejected my prayer, which is below.
Page 24.
Page 24, P5.
So why you are coming after 4 years? Why you are coming after 4 years? It's a compassionate appointment where immediate financial assistance is required to be provided.
That's right.
Why you are coming after 4 years?
That's right. It was passed on 20.
Yes. And it's a case of compassionate appointment.
Yes.
Object of compassionate appointment is to provide immediate financial assistance. So it goes to show, this delay goes to show that there was no requirement of immediate financial assistance. So far the bereaved family is concerned.
Apart from that, mood of rejection, you also kindly.
Yes.
Sir. Grounds of rejection. May I read that?
Yes, read it.
The last time, it is found that the family income as determined from gross pension, family pension, is not less than initial gross salary of Group B employee at the material point of time, that is on the date of death. Let Vidyut Boron Bhakto. So the family is not an extreme financial RC as per expression described in para 1, Schedule 5, Rule 2021 of the School Education Department notification number 12, dated for.
Where is the wrong in it?
Prayer for appointment.
Where is the wrong? That is the yardstick.
But that is in respect of the primary teacher.
Who says so?
But you also kindly see. You also kindly see.
এটা দাও তো।
Secondary also. Kindly see. This is the 20 and
Rules may be called West Bengal School Service Commission Selection of Persons for Appointment to the Post of Non-Teaching Staff Rules 2009. It applies both to the secondary as well as primary school. In case of primary school, it will only apply when the dependent applies for appointment in secondary school. Where from you have got the impression that it applies only in primary school?
As per
This is the only rule for appointment in secondary school. That applies to the case of primary teachers, a death of primary teacher in harness, also in case of death of teaching non-teaching staff who dies in harness in while working in secondary school. But it is made applicable in case of death of primary teachers in the event dependent family, one of the dependent family members applies for appointment under death in harness category in secondary school, not in primary school. You will find that in out of 100 cases in relating to appointment under death in harness category in connection with death of a primary teacher, applications are made for appointment in secondary school. Why? Because in most of the cases, candidate does not possess requisite qualification to be appointed in primary school teacher. The state qualification and other training qualification is must. Not state, but the training qualification is must in primary school. So that's why if this is the this is the rules, then the TI has taken a decision in terms of Schedule 5. Come to Schedule 5. Yes. For getting appointment, securing appointment of a primary teacher, there is a difficulty. A candidate is required to possess training qualification.
Yes, here I have to check.
That's why in 99% cases, in case of death in harness of primary teacher, applications are made for appointment in secondary school. But there is you have to be already decision is taken by the DI.
Yes.
So where is the anomaly in this decision? Where is the anomaly? And you are coming after 4 years. In case of death in harness.
Some other reason, I could not able to come in.
Sorry, Mr. Bandyopadhyay. Sorry, Mr. Bandyopadhyay. Come with a better case. Yes. Affidavit service filed on behalf of the petitioner is taken on record. Stop. Next paragraph. Petitioner questions. Memo dated 17th August 2021 issued by the District Inspector of Schools AC Purbo Bardhaman, being respondent number 4, whereby prayer of the petitioner for appointment on compassionate ground was rejected. Petitioner prays for mandamus. Petitioner prays for issuance of mandamus, thereby directing the concerned respondent authorities to appoint the petitioner under death in harness category on by setting aside impugned memo dated 17th August 2021. Stop. Next paragraph. On providing a chart in tabular form, respondent number 4 has demonstrated by giving particulars of income that family income of the family of deceased that income of family of deceased teacher is not less than initial gross salary of group D employee at the material point of time or at the time of date of death of the employee, at the time of date of death of the teacher. So, therefore, on following definition of financial hardship, quote unquote, as provided under Schedule 5 2 the West Bengal School Service Commission within bracket selection of persons for appointment to the post of non-teaching staff close bracket rules 2009 inference was drawn that the family of the deceased teacher was not in need of or family of the deceased teacher was not suffering from financial hardship, quote unquote, financial hardship. So, apparently there is no, stop. This court does not find any the impugned memo dated 17th August 2021 is not found to be erroneous. Next paragraph. Moreover, respondent number 4 by issuing memo dated 17th August 2021 rejected claim of the petitioner for appointment on compassionate ground, and present writ petition was instituted on 7 July 2025, nearly after 4 years. Stop. Stop now there, which goes to show that the family of the deceased teacher was not in need of immediate financial assistance to tide over crisis due to untimely death of bread earner. Next paragraph. Hence, no relief can be granted to the petitioner. Writ petition stands dismissed. Urgent xerox admit.
Item number 47.
I'm for the commission.
This is under the transfer application under of the petition. But since initially when she applied on the distance, which after the obtaining from the school and if pending, she can
Applied for transfer on?
Ground of distance. But thereafter this number directed them to consider this. They considered and had a rejection by saying that there are your vacancy position is third and fifth in these two schools, and in one school there is no vacancy. So thereafter,
So a petitioner did not come within the zone of consideration
yes,
in terms of the list prepared against 3 vacancies.
against three.
On the ground of distance, application on the ground of distance.
But thereafter makes an application again, so it's as well as via the school, pointing out 3 more other vacancies. That is not considered. It's not but subsidy with 3 new schools. That is not considered.
You make a fresh application.
This is exactly what she did. Can you come at once to my fresh application?
But in connection with the previous application, this cannot be done.
Or can you come at once? Forwarding letter of my fresh application is.
Where is your previous application?
Or previous sole order of this honorable if I take your lordship, that your lordship will find at page number 21.
Now, in terms of this order date 6th March, where is the decision by the page 24?
24 vacancies.
Not readable.
But I'm sorry. Since that yes,
Just
There are 2 page 24, my lord. Can you see the first page? That is legible, my lord.
This is a document.
But
Right side is not readable.
in my
And
copy,
then the representation.
in my copy there are 2
Offline
page
application.
24, my lord.
Yes.
In my copy there are 2 page 24, my lord.
actually seeing that illegible one, that is there.
Yes.
That is only there in the petition. Visual copy I.
Just a minute. Third and fourth.
Yes.
Third line, extreme right hand side.
Your rank is
Third and fourth.
in your first and third preferred school.
Third and fourth. First and third preferred school.
Third in first, fourth in third.
Yes. Then so therefore you are not transferred. Then what is the date of this decision?
But at this decision, your lordship will see 26th of March 2025.
2025. Where is the original copy?
But
Date is completely erased. How this petition is being filed? I don't believe that the 23rd 6th March 2025 copy was provided to you in this.
if I can conduct your lordship, please let go.
It has not been probably properly xeroxed.
Sorry for this. Yes.
Now your second application appears to be not in form.
Forwarding. The form
Page
starts-
25.
Yes, that is the forwarding. The form order starts at 29. And this request you will also see.
What is the date of this application?
But the forwarding letter, my lord, is the letter which takes all this application, all the annexures and everything. The date of the forwarding letter, your lordship will see. The date of posting of the same, which will actually find at page number
24th of April 2025.
My lord, it is. Yes. Yes. And my lord, can you see screen number 32 was?
That is also on the ground of distance.
Only I just changed the name of this.
Wait, 1, 2. Yeah, and the school authority granted no objection. Then what happened?
Thereafter, it has been kept back.
Before the DI?
Before this school, my lord, because I am not intimated as to whether these have been products forwarded to the school service commission.
Then you have grievances against the school.
But yes, my lord, in the school.
The school has granted no objection.
But it has been.
Yes, Ms. Dubey, there is no difficulty or there is no impediment in considering second application of the petitioner in connection with other posts.
Other schools, yes.
He has applied in the for on distance ground, my lord.
Yes, same distance ground. Once distance ground application was rejected, since the petitioner did not come within the zone of consideration against two vacancies, and in second school there was no vacancy.
But till now the
Now,
application.
subsequently, petitioner made an application for transfer on the ground of distance, indicating separate schools. Now, where is the difficulty? Because now, after amendment, a candidate can indicate more than 3 schools. Because there is an amendment to that extent. But so far, this present case is concerned, petitioner applied against 3 vacancies. Against those vacancies, petitioner was not found to be eligible to be transferred. Now, subsequently, petitioner made an application in prescribed form pro forma. What is the impediment in considering such transfer application?
Lordship, with regard to the medical ground, my lord, they may apply at any time. But when a candidate is applying on a distance ground, there is specific time, that is after proper conclusion of a selection process. When an application is invited from the candidates for applying on a distance ground, at that time they can make, my lord. But once that candidate, till now, the application which are pending in the Uttri portal, that has been considered, my lord, whether it's in a distance ground or on a medical ground.
But the court is passing orders regularly, even in case of distance.
With regard to the applications which are pending in the Uttri portal, my lord, not on the fresh application, my lord. Fresh application with regard to the medical ground.
But there is no such embargo as on the only in Tanushree Karmakar, it was decided that application has to be made in prescribed pro forma since portal is suspended.
As it appears, my lord, the school has given the NOC. Let it be forwarded to the DI and he will take a
That is what the
decision in accordance with law.
Let it reach the commission and commission will take a fresh decision.
And kindly fix this up a time frame.
Yes.
These schools also.
Affidavit of service filed on behalf of the petitioner is taken on stop. Next paragraph, petitioner made an application. Now, petitioner previously filed a writ petition being WPA 3910 of 2025, seeking transfer on the ground of distance. Stop. Said writ petition was disposed of by this court, video order dated 6 March 2025, directing the chairman, West Bengal Central School Service Commission, within bracket, herein after referred to as commission, quote unquote, close bracket, to decide the transfer application of the petitioner within certain time. Pursuant to the order dated 6th March 2025, transfer application of the petitioner was decided by the Secretary of the Commission with a memo dated 26 March 2025. So, it was disclosed in memo dated 26 March 2025 that against first and third preferred schools, petitioner did not come within the zone of consideration for transfer, and vacancy in second preferred school was not existing. Stop. Subsequently, next paragraph. Subsequently, petitioner preferred application for transfer on distance ground. On 24th April 2025, and school where petitioner is presently working and the school authority where petitioner is presently working issued no objection or no objection quote unquote on 29th April 2025. Stop. However, it is submitted that school authority is not school authority till date has not forwarded transfer application of the petitioner to the district inspector of schools AC North 24 Parganas being respondent number 5 for taking further steps in relation to the second transfer application of the petition. So, next paragraph. Since it is found that school authority has issued no objection on 29th April 2025. Now, since it is found that no objection was accorded on 29th April 2025, authority of Hauldenga Amullodhon Rai Vidyapit within bracket HS North 24 Parganas being respondent number 6 to 8 are directed to forward transfer application of the petitioner to the respondent number 5 by fortnight from the date of communication of this order. Stop. On receipt of transfer application, respondent number 5 shall process the same and forward it to the. Have you made secretary as party?
No, Your Lordship.
Forward the same to the chairman, West Bengal Central School Service Commission being respondent number 2 for taking decision. By fortnight thereafter. Stop. On receipt of transfer application, respondent number 2 shall decide the same in accordance with law within 8 weeks thereafter. Stop. Decision to be taken by the respondent number 2 shall be communicated to the petitioner by fortnight thereafter. Stop. It is made clear that suspension of portal. Now, next paragraph. Next paragraph. Aforesaid steps shall be taken by the authorities in offline mode. Next paragraph. It is made clear that suspension of portal shall not be a ground to reject transfer application of the petitioner. Stop. Writ petition stands disposed of or being doctored. Yes. Please give your evidence. Next. Call the matters from the combined list.
Item number 335 from monthly list of appellate side.
And I'm the headmaster at school. I was in this school since 2019 to 17th of February 2020 as headmaster. Thereafter, I joined the second school on 18th of February 2020.
18th February 2022.
Yes.
22.
22. For 3 years, I'm discharging as headmaster in this first. But the earlier school also, but I was the headmaster. Now, what has happened is that you Lordship kindly see 3 pages. The release order has been signed by page 22, which has been signed by the district inspector of schools and the TIC of the school on 17th. But they have also issued last pay certificate and page 22 is the release order.
Release order by the present school?
No, by the earlier school. For present school, there is no problem. This is the earlier school, Purunda Ramakrishna Shiksha Sadan. Page
When you have joined the present school?
But I have joined the present
18
school
February 2022.
Yes. Since 19th June 2019 to 17th February 2022, I was in Purunda Ramakrishna Shiksha Sadan as headmaster. When this release order was issued, thereafter the last pay certificate. Kindly see all are countersigned by the DI and the TIC. Thereafter all the documents checked and verified.
What are these applications?
The application they have filed for addition of party. But I oppose to that. Who are they? But I don't know.
Or can 3 by the school authority, where he had been working and where the allegations of irregularities, that is can 3. And can 1 by the persons who are the guardian, they moved a public interest litigation. Pursuant to that, the commissioner passed the present order, which is under challenge before lordship. In a public
Can 2 is before this court and can 1.
Yes.
But can 3 is not.
No, I'm sorry, can 1 and can 2.
Can 1.
Can 1 by the persons who moved the public interest litigation.
Who are they?
But they were the guardian and the local villagers. And pursuant to that order passed by the public interest litigation court, my lord, the commissioner passed the present order, which is under challenge. But they have not been made as a party, so they are before your lordship by way of can 1. And can 2, Mr. Ray is there, is of the school where he had been working during that particular period.
Who has taken out can 2?
School
authority, erstwhile school authority, where the petitioner has served, he has not made the school authority as party respondent, my lord. Pursuant to the direction of the honorable
Purunda Ramakrishna Shiksha Sadan has not been made
party respondent. Though the commissioner of school education specifically directed the petitioner to cooperate with the audit by visiting the school, my lord. He, in spite of several requests to come before the school, he declined to receive the notice.
Have not made Purunda as party.
But I have no grievance.
And my lord,
I have no grievance.
Tempered document, my lord. They have used the document tempered, my lord.
What you are praying for?
But I have prayed for quashing of the order passed by the Commissioner of School Education. But may I get a chance 2-3 minute times?
Where is that order?
Yes. But first, your lordship turns to the order of the PIL court.
No. Where is the order of the commissioner?
Very. The order of the commissioner is at page 34 to 42.
Now you are working in the second school.
Second school.
Page 34.
Yes. Where is the opinion? Page 41. How the guardians are interested and the outsiders are interested in the school management, but I simply don't understand this. And how they can maintain a public interest litigation against the headmaster. I will, apprise your lordship about everything. Kindly seize the opinion part.
Who is Vikas Ranjan Maiti and others?
That's the can 1 guardian.
Guardians. They filed the
Just
public
let me
interest
go through the
litigation.
order of the commission.
Yes.
ওই লোকগুলোকে দেখে গাল দিচ্ছ তুমি। আমার কেন হয়? কষ্টটা দেখো, কষ্টটা দেখো।
অ্যাপ্লিক্যান্ট কিন্তু কোথায় লিখে পেয়েছে?
দেখো গ্যারান্টি Wider.
Can I answer? Can I?
Yes. Now, why you are feeling shy of cooperating with the audit?
At all. But I am not.
Go and cooperate.
But I tell you. But the auditor has been appointed by the government.
That is the usual system.
Yes, the auditor was not there. But when I left the school in 2022, this
Generally, auditor is appointed by the Commissioner of School Education
Yes,
in respect of different schools, and audit is performed.
I'm grateful. But this auditor was not there.
Yes.
There was a vacancy. Now,
where is the question of vacancy? There is no permanent post of auditor.
No. But there was no auditor was placed ever. 19 and 20. Let me see. But 19 and 20, this audit report was not there. Now,
Managing committee.
I am not shy. They moved a writ petition where the court directed the government to proceed. But the commissioner has concluded the hearing and appointed Mr. Swanso as the auditor. But the auditor never called me. The auditor never given me any notice that you please come and.
So very well, let me direct the commissioner and the district school to hold audit, to convene audit or to perform audit strictly in terms of the order of the Commissioner of School Education, and the petitioner shall extend all sorts of cooperation.
Absolutely. But this is number one. Number two. I am not there in this school.
Let the accounts of the school from 2019 to 2021 to be audited.
That was his period. That was his period when he had been working there.
Yes.
So why you are hesitating?
Who said?
You have challenged this order.
But I have challenged the order, the last part. Can you see whether this order can be is at all sustainable or not? Then your lordship can see considering the above. Why I have come before you? Considering all the above and keeping in mind the allegation and counter allegation against each other, Mr. Swanso Gangopadhyay Swanso has been engaged to the audit of the accounts of the school from the financial year 2019-20, 21-22 within a month. This was done. No call from the auditor. Then the president of the managing committee. This is where I approached you. The president of the managing committee of Swanso School, the present teacher in charge of the school, and Mr. Anupam Nanda, that is me, ex-headmaster of the school, are requested to extend cooperation to the auditor engaged by the Director of School Education West Bengal to the audit the accounts of the school up to Swanso. Then, after getting the audit report, the president of the managing committee of Purshunda Swanso School must place it before the managing committee of the school for discussion. After thorough discussion in the managing committee of the Purshunda Swanso, the president of the school may forward the resolution of the managing committee as well as the allegation against the
May forward.
Yes.
If it is found that there are certain materials,
allow
president of the managing committee school may forward.
Can you allow me 2 minutes? May forward the resolution of the managing committee as well as the allegation against Sri Swanso of the school, now working as the headmaster of Swanso, along with the audit report to the disciplinary committee of the West Bengal Board of Secondary Education for taking necessary action in terms of the Swanso rules. But I am not in this school for last 3 years. How this president I am not under him. how this president can forward my name for disciplinary action against the board. Kindly see, my lord, the power of the board in case of an application being made in 5.1 of the 2018 rules. I am not an employee of the school now. I left the school 3.5 years back. So, my lord, the order, this part of the order, my lord, I challenge.
But who is the discipline authority, Mr. Bhattacharya, nowadays?
Board-
Under the old rules,
Yes.
school authority was the discipline authority.
This was done, my lord.
Now it is the board is the discipline authority.
As well as the appointing authority.
Are Baba Dara? But now the
So,
board.
where is the difficulty?
Now, my lord, the board, yes, the school can send my name for disciplinary proceeding. If I am working in the school, I am not in the school now. I'm in a different school.
That defense would have been available to you in terms of Rule 28.8 of the Management Rules of 1969.
Yes.
Where the managing committee of the school and its secretary were the discipline authorities. But now the picture is changed.
Yes, absolutely. But may I get the book only? The
Which one you want to tell me?
The 2018 rules. I don't have the book with me. Volume 1. Kindly see, 5.1.
This dear with me last.
On the application made, yes. 5.1.
Just support করলে হবে না।
Only on these ground, I'm aggrieved. Nothing else. That I left this school 3.5 years back. Kindly see.
And got rid of the situation.
No, absolutely not. No allegation is against me. I will submit the inquiry report of the DI. Kindly have a look.
So if you come clear after audit, question
no
of,
problem.
Question of referring the matter to the board for initiation of
Absolutely. Absolutely. Kindly see the conduct. Just a second. I'm not confident. Kindly see the conduct of the guardians. The guardians. Yes.
Now there is no problem. Board is the discipline authority.
Yes. Yes.
If your lordship kindly
turns to 5.1. The board may authorize any officer not below the rank of sub-inspector of schools to conduct inquiry, to conduct preliminary investigation against any teacher or non-teaching staff upon receipt of a complaint pertaining to misconduct of a teacher or non-teaching staff from the committee or administrator or head of the institution. Now, which school? I am not the teacher of this school at present. Purshunda, I am not the teacher. 3.5 years back, I left. So, I have no connection with this managing committee.
Previous school.
Previous school.
They will get inputs from the previous school. What is the difficulty?
No, previous school. I'm talking about previous school.
Yes, because you were the employee of that school at the material point of time.
Absolutely.
So does it? If I look at the situation in this manner, that you have committed a misconduct, or there was a charge of defalcation of fund. Now, after conducting this, or after committing this misdeed, you take transfer to another school. Whether such act is obliterated?
No.
Then?
Then this, as I am working under the same DI, the school will refer it to the DI to the board. But as I am not the direct employee of the school, but how can board, but the present school, where the earlier school where I am not at all working for 3.5 years, how he can place my name for suspension? Because I have.
Showing 5.1, but can you see 5.12?
5.12, I know that the board has inherent power, but the matter has never gone to the board. Yes, 5.12 board has inherent power.
You would have been saved. You would have been saved had 28.8 would have been pressed into service. Would have been pressed into service.
But I don't want to flee.
He took transfer. He handed over documents at the office of the DI when Mr. Chopeshwar Sardar was in the chair, who is at present, if I'm not wrong, in custody for committing all misdeeds.
A DI having the post, I have handed over the copies. I have handed over the charge.
You are relying upon 5.1.
5.1.
স্কুলে না দিয়ে ডিআর কাছে দিয়ে পালিয়ে গেছে।
কি করে বুঝবো কোথায় দিয়েছে?
দেখাবো তোমাকে এবার, তোমার ওটাও ফর্জ ডকুমেন্ট দেখে নাও।
এটা
ইয়েস, এক্ষুনি তোমায় দেখিয়ে দিচ্ছি। এবার
এই সইটাগুলো সব ফোর্স।
ক্যান টু বের করো, ক্যান টু বের করো, পেজ 35 এ এসো। পেজ 35 দাদা। এবার জাস্ট ট্যালি করো দুটো রকম।
এই সইটা এখানে
বিষয়টা না থাকতেই পারে, কারণ ডিআইটা হ্যান্ড ওভার করেছে তখনকার সিগনেচার, but something else is there.
পড়ান দেখা
দেখা যাচ্ছে। That's not within my domain. That is within my domain.
একটা আছে।
Then you will let the rule 512 be pressed into, will be pressed into service upon modification of the order passed by the Commissioner of School Education.
Well, I tell you, Lordship, the
And
next
I
part,
will array board as party respondent.
the next part, very interesting. Number the writ petitioners in the PIL, Public Institute Education, they preferred a contempt for violation of the order of the
What
Honorable
was
Chief
the
Justice.
order passed by the Honorable Division Bench in public?
To make a representation by the petitioner before the commissioner, and commissioner was directed to consider this.
Yes.
And that has been, this order has been passed.
This order has been.
That is, the writ public interest litigation was filed by the guardians.
Yes, by my clients.
Some of the members of the
Page 32.
You are representing guardians.
Yes, page 32.
You are representing
Ashfile School, the headmaster of the Ashfile School, TIC and managing committee.
present TIC.
Managing committee as well as the TIC.
Where is the order of the Honorable Division Bench?
Page 32, my lord.
School ballot, some guardians also make a same complaint against the present headmaster.
And he has
Yeah, he also he is going. So many allegation has been made.
Now, if Stanley turns to page 35 of Can 2, he has tampered the document of the school. It is apparent. I have annexed both of the documents.
I have not a single allegation against me during my tenure.
Because these documents was invented after 5.
It's
through this writ petition.
It's a release order.
Now this audit has not been conducted till date.
School
Kindly
authorities
says the
four letters, but every time he has refused to accept the letter. And director of school education has also engaged the auditor.
As if by taking transfer everything is obliterated.
Well, I am not. Kindly see the last order of the Public Interest Litigation Court.
It is abide by the result of the writ.
In contempt. Contempt is also act yes. Kindly see the order of the contempt. This part has been waived.
Subsequent হয়েছে এটা। No. About 65 of 2024.
Paragraph 8.
Inspects advantage telling the order of the Commission of School Education. CPN এর order ছিল সেটা। This is something else. 2024 implementation. ইমপ্লিমেন্টেশন চাইতে সেটা দেখাচ্ছে অরিজিনালটা তো যায়নি অরিজিনাল 2022 has not been touched. Second page এটা second page এটা আবার second
যেহেতু পেন্ডিং
দেখ পুরো
And the division bench has said, which I am also saying, that we make it clear that mere transfer of the petition, respondent number 9, in the meanwhile will not absolve him of liability if any irregularity was committed by him during the period he was posted in the concerned school.
Kindly see the order dated by
Have you preferred appeal against this order before the Honorable Supreme Court?
No. The kindly sees the order passed by the in contempt. By the court has modified the order. Kindly sees the order of the division bench once.
This order was not modified. But there's a second appeal for implementation of the order of the commissioner. A second appeal was filed, and that was not disposed of initially. Since that is under challenge, we are not touching the issue. The authorities are at liberty; they can proceed. That order has been subsequently modified in contempt.
Yes.
But the order of the commissioner that has not been touched, not the order passed in 22 in the first public interest litigation that has been charged.
And your lordship kindly sees, but just I have handed over 11th of February 2025 by the PIL court, by the Honorable Chief Justice.
That in respect of the second appeal.
Yes, but kindly sees how paragraph 8 and 9. Therefore, without casting any aspersion on the ex-headmaster, already seen the said order.
I will not dispose it of. I will direct the auditor to conduct an audit and through the district inspector of schools shall submit a report.
You can't be better or freeze the date.
Yes.
But before that, kindly see.
Otherwise, petitioner may make an attempt to frustrate the audit by not participating in the audit.
No, I have never said. I have never said that. Kindly sees the order of the Honorable Chief Justice in contempt. Before passing any order. Kindly sees the order dated 11th of February 2025. I have given the copy.
Issue.
Your lordship has seen the order.
In the affidavit of service filed on behalf of the petitioner is taken on record stuff. In the writ petition, petitioner being headmaster of a government aided food.
But as your lordship seen the order in contempt.
Questioned the memo dated 18th May 2023 issued by the Commissioner of School Education West Bengal. Being respondent number 2. Petitioner was headmaster of Purunda Ramkrishna Shiksha Sadan, Paschim Medinipur. And
last line
on transfer, he joined. What is the present name of the school?
Joy Krishna Nehru,
He joined another school
Joy Krishnapur,
with
Nehru
effect from
Vidya Bhavan.
18th February 2022 as headmaster. However, during his tenure as headmaster in Purunda Ramakrishna Shiksha Sadhan, Paschim Medinipur within bracket for short first school, there were allegations against the petitioner of committing misconduct and defalcation of fund. Stop. Taking note of that issue, taking note of those allegations, respondent number 2, in terms of the order dated 15th November 2022, passed by Honorable Division Bench in a public interest litigation being WPA within bracket P 346 of 2022 within bracket Bikash Ranjan Maiti and others versus the state of West Bengal and others. কি বললাম সেন্টেন্সটা? Passed, took decision with a memo dated 18th May 2023. Thereby appointing an auditor to audit the accounts of the school, to audit the accounts of first school. From the financial year 2019-2020 to 2021-2022 within a month. It was also directed by the respondent number 2 that president, managing committee of first school, present teacher in charge of the first school, and the petitioner herein being the ex-headmaster of the first school, to extend cooperation to the auditor to audit the accounts of the first school. So, it is submitted by the learned advocates representing the parties that till date audit has not been conducted. Stop. Court directs the Commissioner of School Education, court directs the respondent number 2 to have the accounts of first school audited within 4 weeks from date by within 4 weeks from date and submit a report before this court on the next date. And submit a report before this court. Stop করে দাও, করে দাও. Next paragraph. Let such report be filed by the respondent number 2 by 6 weeks from date in the form of affidavit. Stop. Next paragraph. President of the managing committee of the first school, present teacher in charge of the first school, and the petitioner herein shall cooperate the auditor to get the accounts of the first school audited within the time stipulated above. Stop. In the event petitioner does not cooperate with the auditor, same shall be disclosed in the report to be filed by the respondent number 2, based on which an appropriate order is to be passed.
That will be informed by the school authority. Otherwise, functional.
But I am here to undertake that I will cooperate. I never said I will never cooperate.
District Inspector of Schools SC, Paschim Medinipur being respondent number 3, shall also supervise the entire audit process and facilitate the auditor to complete the process and submit a report before the respondent number 2 on completion of such audit. Stop. List the matter under the same.
Only the auditor only remains on the path. That my option only clarify because
In the order of the commissioner, it has been there.
Already there. Yes.
So Lordship kindly clarify that auditor will continue.
It is there by the commissioner.
That has been mentioned.
His name of the auditor.
Respondent number 2 is also at leave. Respondent number 2 is also at next paragraph. Respondent number 2 is also at leave to complete the audit
স্কুলে আমাদের
না কেটে দাও respondent 2 at leave. The auditor appointed by respondent number 2 video order dated 18th May 2023 shall complete the audit.
But only one request.
malad can 2 malad
One you have no local custody. You are the villager.
Next paragraph. Leave is granted to the learned advocate representing the petitioner to amend the cause title of this writ petition and add West Bengal Board of Secondary Education and its president as additional respondents in course of this day. Stop. Miss Bhattacharya, learned advocate, is present in court, who usually represents board. Stop. Learned advocate for the petitioner is directed to serve amended copy of the writ petition and copy of the order passed today upon Miss Bhattacharya by
Monday,
18th August 2025. Stop. Applications filed, two applications filed in connection with the writ petition shall be considered on the next date. Next paragraph. List the matter under the same heading in the monthly combined list of October 2025.
Only one request.
My lord, your lordships directed the erstwhile school, my lord, to cooperate with the auditors.
First school, not erstwhile school.
First school, I am appearing for the first school. First school is not party respondent. Therefore, they have made this application for
You
addition.
are appearing for the first school?
Yes, my lord.
Oh.
Then
We are appearing for the villagers.
Villagers, my lord, who dared to move the public interest litigation.
Here,
Yes,
public interest litigation.
yes,
Am I a gunda? That you are there to move.
kind of.
Acha.
You are representing,
Gunda school, my lord.
yes, who are they? Headmaster,
The
teacher
as
in
well
charge.
as the teacher in charge.
Can one?
Can two.
And in the body of the petition, they have never mentioned who are they. The headmaster or teacher in charge and the school.
Here applications কি বললাম দেখো তো applications
October month.
no the first school should be made party.
Yes.
Yes. But my lord, is there any resolution my lord, to file this application for the managing committee?
Yes.
Right? Can the teacher in charge on his own, my lord, he can file it?
More you take technical point, more you dig your own grave.
My lord, I am here. My lord, I am here to my lord,
Yes.
before the court.
It is not the duty of the petitioner to add the first school as party respondent.
I have the grievance against the my lord, only that part.
দেখো শেষে application বললাম।
My lord, this is a mere technicality. He has to take the permission of the managing committee.
Application না ওইটা কেটে দাও। Application being can 2 is taken out by the authorities of Purunda by the authorities of first school, that is Purunda Ramkrishna Shiksha Sadan within bracket HS Paschim Medinipur. Stop. Applications. Stop. Stop. Considering the aforesaid discussion and the issue involved in this writ petition, this court finds applicants in Can 2 of 2024 are necessary and proper parties. Stop. Application being Can 2 of 2024 is allowed and disposed of. Stop. Thereby directing, disposed of, thereby directing the department to amend the cost title of the writ petition and add the applicants in Can 2 of 2024 as additional respondents by 10 days from date. Client advocate for the applicants in Can 2 of 2024 shall cooperate with the department to carry out necessary amendment. So, after such amendment is carried out, client advocate for the petitioner is directed to serve copy of the amended writ petition upon the learned advocate representing applicants in Can 2 of 2024. Stop. Next paragraph. Since Can 1 is preferred by villages, today same is not decided. Let the application being Can 1 of 2024.
Yes, ma'am.
Can of 2024 appear along with the writ petition on the next date under the on the next date. Stop. Combined monthly list of October.
But only one.
Great, madam.
But as I have left the school 3.5 years back, and these allegations are there. But if your lordship kindly, give me some protection, but I will go there. Definitely, I will go there.
I have not directed to initiate any proceedings.
No,
What
no.
protection?
Protection
Let the report be placed.
I
before
may be
this court.
physically assaulted.
Let me go through the report.
But I am not on the report. I may be physically assaulted in the school. That is my presumption. I may be. Kindly protect me on that.
Next paragraph.
Getting out.
While petitioner will appear before the auditor for convening for assisting now for extending necessary assistance to complete audit, he shall not be obstructed by any of the parties to this documentation.
Great, my lord.
আরে ভয়ের কিছু নেই, এটা নর্মাল ব্যাপার।
টাকা মারলে তো ভয় লাগবে।
SDPO has made complaint against.
Let it be placed, let me see.
Yes, yes, but I
What
have
is
no
there in the
problem.
audit?
I have no problem. I tell you, Lordship, that I have no problem. Only matter whether I will be physically assaulted or not.
Yes, yes.
Only this much.
Next,
সবাই যদি সাধু হয় তাহলে আমরা কি করে চলবো?
next.
Item number 337.
Pay for higher scale of teaching. Appointed as a assistant teacher, honors graduate on 15 March 2006. After taking prior
Where is your approval, ma'am?
and see case
You are
21.
for the state.
Case 21.
Again disposed of.
Next, they are admitted.
Case 21 is the prior permission.
Prior permission.
Now, where is your approval memo as assistant teacher? Are you aware of any provision relating to
Page 20.
granting approval of appointment?
Page 20.
Yes. This is approval memo.
Yes. Second column.
So you were appointed on 15 March 2008 and was granted honors graduate scale of pay. Now you obtained higher qualification from which university?
Open University.
When?
Page 21. 2016 session.
Case 21 is the prior permission.
Prior permission.
Now, when you obtained this higher qualification?
2021.
2021. Where is the relevant document?
Page 26. December 2021. Examination of June 2021 held in December 2021.
Upon mentioning. Upon mentioning. The correction.
But it has not been granted to you. No decision has been taken.
I made a representation.
And you obtained prior permission.
Prior permission. Page 37.
Yes, after granting prior permission, why DI is not granting higher scale of pay? It is not a case that no prior permission was granted.
Page 37 is my representation to the school.
Have you made any representation to the district inspector of school? So you make a representation stating all these things. But by this time it should have been granted when prior permission was issued by the ADISC Ulberia. Nodding head will not do. We have to give clarification. Why DI has not done this? Yes. Why it has not been done?
Lordship taking instructions.
When the writ petition was filed, 21st February 2024, and you had to take instruction now.
In the meantime, transfer mutual consent, that is page 30, and the approval page
Under the same DI or under a different DI, then what will happen? We will take decision because you obtained the qualification under a different DI. Now who will take decision now?
Let them commissioner to.
These are the problem.
Let the commissioner to take a decision.
Have you filed any application as a supplementary affidavit indicating that you have taken transfer? Whether you have disclosed it in your writ petition that you have taken transfer?
I have disclosed.
Where?
Here, page 30. Transfer on mutual consent. There are approval.
Page 31.
Page 30. 30.
Previously, you were working under which school? In which school?
Howrah. Previously.
Now you have been transferred to his district.
South 24.
Neither South 24 Parganas DI can decide, nor how DI Howrah can decide now, in view of your transfer.
Right, the commissioner. Make a representation. Commissioner to decision.
Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Stop. Petitioner was an assistant teacher. Or petitioner was appointed as assistant teacher. On 15th March 2008. Petitioner was appointed as assistant teacher of mathematics on 15 March 2008 and was sanctioned postgraduate scale of pay. Since petitioner was possessing honors graduate degree in mathematics, so petitioner obtained prior permission from the ADI from the additional district inspector of schools within bracket AC Ulubedia subdivision Howrah. Read a memo dated 22nd September 2016 for taking admission in postgraduate course in mathematics for the session 2016-18 under Netaji Subhash Open University. And such prior permission is at page 21 of the writ petition. Subsequently, petitioner completed postgraduate course and obtained master degree. The certificate was issued conferring postgraduate degree by the university on 8 February 2022. Stop. Petitioner prays for sanction of postgraduate scale of pay. State respondents are represented by learned advocate. Stop. Next paragraph. তার আগে স্টেট রেসপন্ডেন্ট একটা প্যারাগ্রাফ করে it is also informed by the learned advocate representing the petitioner that petitioner was transferred from his previous school situates at Howrah to Gauripur Sri Sri Ramakrishna Vidyapit HS.
That is the first school.
Next, second school is Dara Adarsha Vidya Mandir.
I see. So to Dara Gauriputta Kededa. To Dara Adarsha Vidya Mandir within bracket HS. Situates in South 24 Parganas. জিনিসটা কি বললাম পিটিশনার ওয়াজ ট্রান্সফার্ড হবে না পিটিশনার মিউচুয়াল না পিটিশনার ওয়াজ মিউচুয়ালি ট্রান্সফার্ড তারপরে স্টেট রেসপন্ডেন্স এন্ড রিপ্রেজেন্টেটিভ ল্যাঙ্গুয়েজ নেক্সট since petitioner obtained postgraduate degree in relevant subject of teaching and prior to enrolling himself with the university or undergoing higher course of study, petitioner obtained prior permission from the additional district inspector of schools within bracket AC close bracket Uluberia subdivision Howrah on 22nd September 2016. This court finds that prayer of the petitioner for sanction of postgraduate scale of pay needs to be considered in accordance with law. Next paragraph. Leave is granted to the petitioner to make a representation claiming sanction of postgraduate scale of pay by fortnight from date before the Commissioner of School Education West Bengal. Stop. Have you made commissioner party?
Yes, respondent number 2.
Being respondent number 2. Stop. On receipt of stop. If representation is made within the aforesaid time, respondent number 2 shall decide the same in accordance with law within a period of 8 weeks thereafter on granting opportunity of hearing to the petitioner or his representative. Stop. Respondent number 2 shall pass a reasoned order and at a time of taking decision, prior permission issued by the additional district inspector of schools AC Uluberia subdivision Howrah dated 22nd September 2026 22nd September 2016 shall be taken into consideration. Decision to be taken by the respondent number 2 shall be communicated to the petitioner by fortnight thereafter. Next paragraph. Writ petition stands disposed of. Urgent xerox certificate. Next.
Item number 338.
I'm happy for the state respondent.
I'm for the commission. This is related to my first SLST for my 910.
Petitioner praying for transfer.
No, transfer. No, made an RTA application challenging non-supply of information. Yes.
At the time of call, no one appears for the petitioner and no accommodation is paid for. However, respondents are represented by learned advocates. Stop. Writ petition stands dismissed for default. Parties to act on the server copy.
Item number 339.
Paper for the petitioner. My after of service, my lord. Other of a candidate who appeared in the Madhyamik examination in the year 2023. The examination was ended on my lord 3rd March 2023 and 19th May, my lord, the result was published. Thereafter, my lord, the mark sheet has been given. The petitioner got 682 out of my lord 700 marks. 90, most probably 98% marks. But petitioner was an aspirant that he may come under my lord the zone of one within my lord rank 10. He stood in rank 11, my lord. Thereafter, my lord, the father of the petitioner made representation, my lord, made application under RTI Act to supply the my lord, certified copy of the my lord, the answer script of mathematics, Bengali, and life science. Those answer scripts had been given. My lord, thereafter, my lord, the petitioner produced that answer script that in Bengali and also, my lord, the life science, some marks has been, my lord, it is penned through, and thereafter some marks has been given, my lord, in 3 questions, my lord. My lord, no signature was there, no signature of head of the examiner was there.
Give me the best case. Show me the best case where it was interpolated and a different marks was given without any signature by the examiner.
Kindly produce
Show me the best example.
Page 36.
my lord, kindly, my lord, come.
Yes.
Page 36, my lord. 36, 37, 38, 39. This is the question number 3.2.2.
Yes.
Here the marks was
1 plus 1, 2 was given.
no, my lord. Kindly come to the bottom. My lord.
Yes, 1 plus 1, 2 was given.
There was, my lord, 3 marks. It is, my lord, cut, my lord, pen through, my lord. There is now there are now the number was given, my lord, 2. Then 1 plus 1. There was 3. My lord, previously there was 3. Now there is, my lord, 2. Now next page, my lord, come. 4.2 in the middle, 37. Previously there was given, my lord, 2 marks, then 1.5 marks. 2 or
No,
3.
it was not 2 marks. Which is struck off is not 2.
It's a half also, half
It is
written.
half.
Half, something half.
It was half. It was enhanced to 1.5.
Next page, my lord. Next page, page 38.
Issue.
Page 38, my lord, kindly come. Well, the number was given 5. It is, my lord, struck off, and there are the 3.5.
Affidavit service filed on behalf of the petitioner is taken on record. Stop. Petitioner is the father of an examinee who participated in
My lord, kindly pay to
Madhyamik Pariksha 2023.
answer script of life science, my lord, also. Now, I have given the, my lord, my lord, example of, my lord, the book, my lord, where from the answers has been given, my lord.
Petitioner performed very well in the aforesaid examination and was awarded 682 marks out of 900.
And also he stood rank 11, my lord.
However, petitioner was not satisfied with the marks awarded to him.
682.
Awarded, however, ভুল হচ্ছে এটা ঠিক করো examinee, father of the examinee was the petitioner. The student performed very well. However, the student was not satisfied with the marks awarded to him in life science.
Bengali and
life science.
In Bengali and life science.
This is the, my lord, life science paper.
Bengali.
No, this is Bengali paper.
Now, Bengali and life science,
This is
which
Bengali.
prompted the petitioner to apply under Right to Information Act before the concerned authority of West Bengal Board of Secondary Education, seeking supply of authenticated copies of answer scripts of those two subjects. Stop. In response to application under Right to Information Act, answer scripts were supplied to the petitioner. And copies of those answer scripts. Now, authenticated answer scripts were supplied to the petitioners. Authenticated copies of answer scripts were supplied to the petitioners. Stop. Copies of those answer scripts are annexed to this writ petition, and the learned advocate representing the petitioner has made an endeavor to demonstrate that while evaluating some answers of answers of life science and Bengali, there were overwritings without any endorsement or signature by the examiner. Stop now. Requiring reassessment of answer script, requiring re-evaluation of answer script by a different examiner. Stop. Next paragraph. Prayer made by the petitioner is opposed by the learned advocate representing representing West Bengal Board of Secondary Education being the examining body, since there is no statutory provision which permits a successful candidate of Madhyamik examination to apply for re-evaluation of answer script. So,
I have also annexed the model.
reliance is placed on answer to question number 3.2.2 of Bengali paper.
Yes, Bengali.
Of Bengali paper, in order to demonstrate that answers were not properly evaluated and there was overwriting. Stop. On perusing answer to question number 3.2.2, it appears that there is overwriting, but at the same time it also appears that there is no difficulty in understanding the marks allotted to the candidate.
4.2 also, my lord.
Allotted to the candidate by the examiner.
4.2 or 5.1. Page 40 also overwriting. Another question. 3 questions overwriting.
It is not a case of erroneous scrutiny or any answer is left without allotting any marks or without allotting marks. Therefore, this court does not find any error in evaluating answers
Only
My lord, only in life science.
by the examiner.
Top. Only in life science, no.
Next
number has
paragraph,
been
in
given.
this regard, reliance is placed by the judgment of the Honorable Supreme Court reported in 2018 to ACC 357 within bracket Ranvijay Singh and others versus State of Uttar Pradesh and others. In paragraph 30.2 of Ranvijay Singh Subsutra, it has been succinctly held by the Honorable Supreme Court that if a statute, rule or regulation governing an examination does not permit re-evaluation or scrutiny of an answer sheet, then the court may permit re-evaluation or scrutiny only if it is demonstrated very clearly without any inferential process of reasoning or by a process of rationalization, and only in rare or exceptional cases that a material error has been committed. While considering the case made out in the writ petition and looking at the answers written by the petitioner, which was evaluated by the examiner, it does not appear that any material error was committed by the examiner. Next paragraph. Hence, no relief can be granted to the petitioner. Writ petition stands dismissed. Urgent xerox certificate.
Only one thing, my lord. Lordship says no marks has been left. He claimed in the paper of life science, no mark has been given. Pair has been made, but marks has been given. Page 84. Page 84.
Yes, very good student. That's why.
Yes,
90.
student is. That's why the student has ambition to get more marks, but sometimes it is not possible.
98 page.
Good students, if his rank is 10, he will aspire to become first. A student, if he ranks 15, he will aspire to become fifth. A student, if he ranks 30th, he will aspire to become 10th. So there is no end to it. Yes, next.
Item number 340.
Matter relates to Malad.
SLST 2016.
Is not Malad headmaster. First SLST appointment of headmaster. Malad, he has not participated in the counseling.
First SLST, when it was conducted?
2019. Malad, panel published on 16th of January 2019, expired on Malad 15th of January 2019.
Just a minute, when panel published?
16th of January 2019.
Expired on?
15th of January 2020.
Any earlier petition?
No, Malad. Petitioner called for counseling, he has not participated. Malad, thereafter in...
Where is the nomenclature of the selection process?
Malad, kindly turns to page 38. This is the intimation letter for counseling.
Especially in these matters, before me, adjournment is prayed for. Because members of the bar know that it will be posted in the next monthly list. Yes, where is the nomenclature?
Intimation letter for the first page of counseling.
Page 38.
Page 38. This is the intimation letter for counseling. Malad, it is on. He was directed to appear on 5th of
First state level selection test 2017. Headmaster.
Date of reporting. Thereafter, Malad, he made representation on Malad 23rd of February 2022. First time.
Just a minute. Yes, where is your right? After the panel expired on 15 January 2020.
Actually, the council is, and I'm very not engaged.
Issue. Writ petition is taken up for consideration when learned advocate representing the petitioner has prayed for adjournment and same is refused. Stop. West Bengal Central School Service Commission is represented by learned advocate. Stop. Having heard the learned advocate representing the commission, it appears that petitioner participated in first state level selection test 2017 within bracket headmasters / headmistress. Stop. It is apprised that panel was prepared on 16 January 2019, which expired on 15 January 20. Panel was prepared on 16 January 2019, which expired on 15 January 2020. Stop. Writ petition was filed on 22nd February 2024. After 4 years, questioning aforesaid selection process.
Praying for counseling, participation in the council.
And prayer is made for participation in the counseling. Stop. Next paragraph. It is tried law that after expiry of the panel, candidate loses right to question the selection process and his right to participate in counseling gets extinguished. Stop. In this regard, reliance is placed on the judgment of the Honorable Supreme Court reported in 1996 9 SSC 309, State of Uttar Pradesh and others versus Harish Chandra and others, and another reported in 2009 2 SSC 706 within bracket Girdhar Kumar Dadhich and another versus State of Rajasthan and others. Stop. In view of aforesaid discussion, no relief can be granted to the petitioner. So, writ petition stands dismissed. Next.
Item number 341.
Yes, my lord, for pension payment, issuance of pension payment order, and my lord, release of pension, arrear pension, gratuity provident fund.
It has been released.
No. Lord,
Just there is an order passed by a coordinate bench.
yes, my lord, during pendency of the matter, authority has not only provided fund of 5 years.
That instruction I have. There is some criminal payment.
There is a criminal case pending against the petitioner.
I have my lord, dictated superannuation, my lord, held my lord, 31st January 2022. Criminal case initiated after 9 months from the date of superannuation. That is afterthought. So that is another issue, my lord.
But today, since the criminal proceeding is pending, apart
is
from
not
provident
related-
fund and provisional pension, you are not entitled
related
to
with
it.
my lord, service benefit, my lord.
That is not the test as contemplated or provided in DCRB scheme 1981.
My lord, in page 30, I have
Paragraph
my lord,
19,
made representation
clause 19.
to the authority, my lord.
Only you are entitled to get provisional pension and provident
Your
fund.
lordship kindly granted.
But during
Kindly
pendency of the
granted,
criminal
my lord. I am
proceedings,
suffering, my lord, 25 years more than I have.
where is the
served.
school authority?
School authority, my lord.
They are not very party.
Yes, I have not made a party, my lord.
Why?
Lord, my grievance was there.
No.
I have.
That has been
before-
initiated at the
before
instance of the
superannuation,
school authority.
Superannuation, my lord, I was the head.
School authority has to prepare
Yes.
the papers. Why you have not made school authority as
I
party?
was the headmistress, my lord. I have, my lord, e-pension file has been sent
Before primary retirement. Kindly see.
Why you have not made school authority as party?
Your Lordship kindly give me the liberty.
You could have done this
That was
earlier.
not done.
The order
You-
could have been passed.
Milord, that was not done, Milord. Only this reason that I was the
You are working in which school?
Milord, school is Milord, Mathurapur Balika Vidyalaya.
Where you have stated the name of the school?
Milord, paragraph 2.
South 24 Parganas?
Yes.
Issue.
After with that, why not she was contacted, but she did not contact with the school.
Petitioner on attaining age of superannuation on 31st January 2022 did not receive retirement dues including pension triggering present writ petition. Stop. Petitioner prays for release of retirement dues including pension. Next paragraph. However, now stop. Though petitioner was headmistress of Mathurapur Balika Vidyalaya within bracket HS close bracket South 24 Parganas, but state school authority has not been arrayed as respondent. Next paragraph. Leave is granted to the petitioner to amend the cause title of this writ petition and array head of the institution of Mathurapur Balika Vidyalaya within bracket HS close bracket district South 24 Parganas and the president of the managing committee of the said school and the said school as additional respondents by amending cause title in course of this day. Stop. After such amendment is carried out, learned advocate for the petitioner is directed to serve notice enclosing amended writ petition and the order passed today upon the additional respondents by fortnight from date and file affidavit of service on the next date. Next paragraph. List the matter under the same heading in the monthly combined list of September 2025. Next.
May I file the report?
Yes, file your report. There was a direction to file report. No, it's not required now. I have not called for any report now, Ms. Rai Mukherjee.
Item number 342.
We are applying for date, my lord.
At the time of call, no one appears for the petitioner and no accommodation is paid for. Stop. However, state respondents are represented by learned advocate. Stop. Writ petition stands dismissed for default. Parties to act on the server copy.
Deeply.
Item number 343.
Moved assistant teacher at present working in filial office. The time of his appointment, his qualification was BA honors in English. Honors in English. Thereafter, he passed BA examination also.
Thereafter,
he passed BA also. But in order to enhance his qualification by completing MA in English, he made representations to the school authority, praying for sanction of leave. But the school authority transmitted all the records to the office of the DI that my client applied for sanctioning of leave and permission so that he may pass MA in English. Thereafter, the school authority also represented the case to the board, praying for so that the board will grant leave for the period when the examination will be held. Board granted leave. And thereafter, my client completed passed MA in English. That certificate is also also annexed with the leave petition. But hence, my client is entitled to get higher postgraduate skills of the But he made a representation to the DI. DI rejected the such prayer on the ground that.
Where is the order of the DI?
But page 60. Page 60.
Where is your approval of appointment?
Approval, yes. But that I have also annexed to the page 29. No, 24. Page 24.
Just read.
One approval and the last approval also I have annexed. Very good. I was allowed to join that assistant teacher in Tiljala High School. But that approval also I have annexed. Yes.
Now, you are appointed on 24th April 2008.
Yes.
Now, when you obtained qualification?
2014 or 2008.
From which university?
Page 41.
From which university?
From Sikkim. Distance education.
Now, you show me that you took admission in the main campus at Sikkim. Otherwise, it's not a valid qualification.
But,
if you have taken admission at a study center here at Kolkata or a franchisee or in a franchisee at Kolkata, it's not an approved qualification.
The board has sanctioned leave also.
That is not the issue. Court is taking this point in view of judgment of Professor Yashpal by the Supreme Court.
But page 37 kindly consider page 37.
EIILM University Sikkim
Yes.
may be a recognized university. I am not saying that it is not recognized university.
Page
But if you have not taken admission in the main campus of the university and you have obtained the qualification through distance mode of education by taking admission at a study center at Kolkata, then that qualification is a question qualification.
Kindly consider page 37.
Have you disclosed it in your writ petition?
Page 37 kindly consider. Page
Issue.
37. Page 37.
Let affidavits be. Petitioner is an affidavit of service filed on behalf of the petitioner is taken on record. Stop. Petitioner is an assistant teacher who was appointed. What is the subject?
English.
Petitioner was an assistant teacher who was appointed on 24th
Language group English.
24th April 2008 and was sanctioned postgraduate and was sanctioned honors graduate scale of pay. Stop. Petitioner subsequently obtained postgraduate qualification in relevant subject of teaching from EIILM University Sikkim. When you obtained the 2012?
No, this is page 41.
2014?
Yes, 2014. Page 41.
In 2014. Stop. Petitioner prays for sanction of postgraduate scale of pay. In consideration of his on consideration of her postgraduate qualification obtained through distance mode of education from EIILM University, Sikkim. Stop. Question next paragraph. State respondents are represented. State respondents and West Bengal Board of Secondary Education are represented by learned advocates. Stop. Question arises for consideration whether petitioner obtained, whether petitioner took admission at the main campus of the aforesaid university in Sikkim or by taking admission in study center at Kolkata and on undergoing distance mode of education obtained such qualification. Stop. Such aspects are not disclosed in the writ petition. In order to consider whether qualification obtained by the petitioner is a recognized qualification or not, these facts are relevant. Next paragraph. Issue needs to be decided on exchange of affidavits. Let affidavit in opposition to this writ petition be filed by 4 weeks from date. Stop. Affidavit in reply thereto, if any, be filed by 2 weeks thereafter. Next paragraph. Petitioner shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging affidavits. Next paragraph. School is party.
Yes.
Learned advocate for the petitioner is directed to communicate this order to the non-appearing respondents by 7 days from date and file affidavit of service on the next day.
Yes.
I'm good.